My lord, praying for inclusion, my lord, in view of the encroachment, coordinate bench had fixed the matter and had directed personal appearance of the additional district magistrate. But my lord, since
When?
my lord, the matter was fixed on 10th November 12, 2025.
No, what is the date of personal appearance?
November 12, 2025. It has passed. But in the meantime, change of determination.
All right, hand over the
My
slip.
lord, upgradation, my lord, ground of urgency I have mentioned.
You mentioned one motion.
Inclusion motion. Please hand over the
Motion,
slip.
Great
motion.
May your lordship sleep. My lord, I am mentioning for accommodation, my lord. Only for this, one day, my lord, I have taken consent for other side. 26th of today.
26.
One
what
badge is
ground?
for the, my lord, the other side, my lord. I have taken consent, my lord.
So, why are you praying for adjournment?
But, only accommodation for this day only.
Why?
My lord, I have to go somewhere.
All right.
Storage.
You are for the petition
Yes,
on the prayer of the learned advocate for the
Lordships, kindly to mention item number 128 of your 126 of your lordships list on the last date, my lord. This was a residuary matter. At least the case status shows that it's a residuary matter. It was on the presentation form. It was supposed to appear before Honorable Justice Ritoproto Mitra. It wrongly appeared before your lordship, and it has been dismissed for default. That is the only thing. It was,
But I,
the slip. Yes.
but I mentioned one.
this is a case
upgradation,
status.
my lord.
my lord.
Upgradation, my lord.
Upgradation, please hand over the slip mentioning the
May I
urgency.
have my lord leave to mention a review application of an order passed, my lord, to be taken up by my lord sitting with Justice Supratim Bhattacharya, my lord. Some urgency, my lord. I appreciate, my lord, only on
This month, no Fridays are available.
30th.
30th, I think I have a bench with the Honorable Chief Justice.
We will try our luck, man. Kindly.
Please hand over the slip because other matters are there.
I'm grateful, my lord.
Yes, call the list.
Inclusion in the
Your
list.
lordship, may I be out of mention one matter? New motion, your lordship.
New motion, hand over the slip.
Inclusion in the list.
Please call the list.
I pay for the petitioner lordship in this matter.
Yes.
I am for the opposite.
Why to
Plenty
mention?
purpose.
Lordship, this is an assigned matter before your lordship.
Assigned, yes.
Yes,
Civil division.
civil division.
Yes, what is the issue?
Lordship,
Order 7 rule. Sorry.
rejection of an order of an application under Order 7, Rule 11, taken out at the behest of the defendant number 1. That is
Barred
the
by law.
no cause of action.
No cause of
Lack of cause of action. That is
Plaintiff fails to disclose cause
yes,
of action.
yes. Plaintiff fails to. This is the moot issue, lordship. So this is a suit for specific performance of contract.
All right. This is not appearing in the list or in the monthly list. It was appearing in the monthly list. No.
No, lordship had last extended the interim order till the end of February.
On 2nd of January, your lordship.
So I directed this matter to
yes.
appear as.
And lordship, while sitting in your lordship's determination in the civil divisional determination, was pleased to fix this matter for hearing. Thereafter, the determination changed.
It's an assigned matter.
Assigned matter, lordship. February, end of
End of February.
How much time both of you will take?
lordship.
I know it's a conservative estimate, but
Basically,
get an idea as to when this should be fixed.
Possibly, I'll take 40 to 45 minutes.
45 minutes. In order
Because
7 to 11, then it has to go to trial. Order 7 rule 11, if
No,
you take 40 to 45 minutes, Then it has
Lordship,
to,
I will have to, because this is not a conservative estimation, and seeing my senior Lordship, I will have to take a little.
looking at your
maybe-
adversary, you have,
Yes. I will have to.
I was about to say that because I will tell only after my learned friend says, because I was telling her that scared of her.
No, Lordship, it is not so.
কোথায়? আমাদের?
uh, 27th, 3 p.m. Yes, madam, 27th.
But ওই মানে first day.
Difficulty.
No, only thing is, my lord, after this long, from 23rd to 26th.
27th, you may not be available.
No, I will be available, my lord. Kindly keep it for that. Can it be first week of February? Subject to my lord. First week of February.
February,
Lordship.
Thursday.
Lordship.
Mr. Mitro, 3 p.m. with that understanding.
Very well.
Because
Very well.
hearing matters, if it goes on at a stretch, otherwise,
Normally, my lord, Thursday it does not happen.
that is why I
Normal.
kept it on Thursday, but
It happened
sometimes,
yesterday.
yes.
Happened yesterday.
This matter.
Deeply object.
Yes, call the next matter.
Pilot item number 3 for correction, my lord. The date of representation has been changed.
Date of
Representation wrongly stated in the order, my lord. Order dated 7th January.
order dated 7th. What is the date of the representation?
Date of representation is, my lord, October 31st, 2025.
October 31st instead of October 10. It has been
Yes,
mentioned
yes.
October 10. Other things
Yes, my lord.
there
There are
in two places.
3 places.
All right. So I am saying that the date of the representation it will
Yeah.
follow.
I have the correction copy, my lord.
Learned advocate, you are for the
I'm for the.
yes. Oh, it is that matter.
Yes, my
Yes,
lord.
that
Yes, my lord, kindly leave may be granted after filing this writ application. Another notice or letter also issued.
Another letter.
Yes, same handwriting, same person, my lord.
Well, the
मतलब
Yes,
page
Mr.
3
Government Leader, yes.
কি দিচ্ছেন এটা?
और एक letter. Page 3, my lord, kindly see.
All right, give a copy. All right, yes, what is the instruction?
Malad, this, so far as Malad, the two plots you also wanted to know. No, দিতে হবে না। এটা কি? Instruction.
Special, এটা আর এটা special. এটা।
দাম দেখছি, আমি বলে দিচ্ছি। Now, my lord, your lordship wanted to know about the pages 48 to 53 of the writ petition.
Veracity of those documents.
Yes. So, my lord, this, so far as the first document is concerned, my lord, I've got the written instruction. If your lordship want, I can hand up. But my lord, this is not in, no, just দেওয়ার মতো অবস্থান, স্টিচ ফিচ করা নেই, কিছু করা নেই এবার।
All right, make submissions, I can give you, yes, what is the instruction?
My lord, the first document page, first, শুনুন, আমি বলতে দিন। This is my first document, that is page 48. My instruction is that it is one of the documents was indeed issued by the competent office in ordinary course of official business. However, the handwritten portion appearing on the blank space below the typed documents under the seal and signature was not written by respondent number 13, nor was it made at his instance or with his authority. So this is a manufactured one.
Who has made this?
The handwriting was subsequently inserted after issuance and does not form part of the official communication. My lord, second
Government
document,
Leader, today also and supplementary affidavit, same handwriting.
my lord,
Somebody,
this is something. My lord, the second document is wholly concocted. That's my written instruction in bold.
second document means this.
Type
Yes,
page 50.
entirely fabricated and is the concocted one. Does not emanate from the office of the respondent number 13. Respondent number 13.
No, Partho Sarathi Roy
Yes,
and
yes.
Robin Khilari,
Yes.
who are they? Have you identified them? And whose signature are appearing in page 52?
Page
There are two
50.
signatures. Whose signatures are this?
My lord, this is, my lord, this is the tampered one, my lord, this is fabricated. This doesn't bear the signature of the authority.
Partho Sarathi Roy and Robin Khilari, are they employees?
Yes.
LA Kurmi and LA Assistant Director.
My lord, lordship,
Have you
kindly,
identified these two persons? Partho Sarathi Roy and Robin Khilari.
no, my lord, no.
So this they have to be identified. Their names are appearing here.
Yes.
And somebody's mobile phone number is also
Yes.
there.
I'm grateful to
That is, lordship, it is there. It is there.
Both of their mobile numbers are there.
এটা তো কি হলো দেখো তুমি বলেছি আইডেন্টিফাই করা গেছে লর্ডশিপ গিভস মি মিনিট
অ্যাসিস্ট্যান্ট ইঞ্জিনিয়ারের নামই বলছে অ্যাসিস্ট্যান্ট ইঞ্জিনিয়ার তো করেনি সে তো ডিনাই করেছে এই যে
ডিনাই করলে হবে না আইডেন্টিফাই করা গেছে কিনা
হ্যাঁ আইডেন্টিফাই
আইডেন্টিফাই
হ্যাঁ ওই
Partho Sarathi Roy and Robin Khilari are your staffs. Then they have to affirm an affidavit.
Lordship, I think, my lord, I should come with either a report or an affidavit. I find, my lord, that this is the serious issue, my lord.
Another supplementary affidavit
Yes, my lord,
appears to
kindly
be in
see.
the same handwriting.
Malo, may I read it?
Because
Kindly appreciate the language, threatening, demanding money.
এটা কোথায় কি করে হচ্ছে এগুলো Lordship says,
somebody is doing this mischief.
oh, they are one of the office staff. Robin Khilari is Group D employee of the and the other and he other one the Partho Sarathi land acquisition officer.
They have to be implemented. They have to file affidavits.
Yes.
Because
Yes,
their
yes,
signatures are
yes,
appearing.
Yes,
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 yes.
my
Their signatures
Yes,
are appearing.
yes. But this kind of should not be indulged. This should be brought to the notice. It has been brought to notice of the court, and it should happen in the third place. Yes.
This is one part. Second is, what do you say? This will proceed. Inquiry and other things will proceed. Now the issue is with regard to encroachment
Yes,
of the PWD road.
Yes.
All officers are saying this is not within my jurisdiction. So within whose jurisdiction this particular property falls?
আচ্ছা ল্যান্ডের এটা দেখি yes I've got the report there are two plots of land. One is plot number 770
Plot number
770
paragraph
uh
you have stated. Yes, 770
yes
and another
another is 771
771.
yes
Yes,
well this so far as 770 plot is concerned
yes.
this is recorded in Khotiar number so and so patta is recorded as patta in the name of Nomita Dolui.
মানে this is the false statement 770 intact.
Just a minute, আমি বলতে বলে নেই একটুখানি I feel pressure.
Sorry.
Yes.
Now this plot number 770 my written instruction from the land acquisition officer is that this land is recorded in the name of Nomita Dole as patta holder. So this
This was a vested property. There are
yes patta granted yes patta.
For what purpose?
Malad the I take it from this patta এখান থেকে দেখি patta mule bastu Nomita Doloi such and such. মানে the রায়তি লেসির বিবরণ পশ্চিমবঙ্গ সরকার পক্ষে কালেক্টর নিজ পাট্টা পিতা পাট্টা মূলে নমিতা দলে পাট্টা গ্রান্টেড শ্রেণী এটা কি কালাটা কি বাংলায় আমি বুঝতে পারছি না মানে one is kala and another is bastu. This both are in patta both are in plot number 770 dag number 770 শ্রেণী kala and another is bastu.
Yes.
পাট্টা হস্তান্তর নিষিদ্ধ পাট্টামূল নমিতা দলই. This is malad so far as 770 is concerned and 771 this is malad this is also malad this is yes recorded there malad this total area is 0.08 acre recorded in Khotiar number so and so in the name of Bimal Kumar Dotto, Kamal Kumar Dotto, both sons of Manoranjan and Rajkumar Maji. Copy enclosed.
Next page.
This is malad this I find malad the record of right is given. This is malad they are said to be the riots. Both malad this yes.
And there is an allegation of encroachment upon the highway.
Yes. Encroachment of highway malad
PWD road, upon the PWD road. What is your instruction with regard to that?
malad Lordship malad
You can file a report.
I should malad there are many things
Yes. Who will file the report?
malad this
Sub-assist,
this is malad the assistant engineer Ghatal highway subdivision.
It should be Ghatal.
Assistant engineer Ghatal highway subdivision PWD roads directorate.
Which respondent?
Respondent number কত বলুন Disposition respondent number disposition
13.
yes 13 13
13.
13 lordship 13
So let 13 file an affidavit with regard to this. And with regard to the other part, please make an inquiry and please submit a report.
yes yes
And I'm directing him to implead this.
yes
These two persons.
these two persons the group D and malad the land acquisition officer right the land acquisition officer
Pursuant to instruction is if those are concocted or I shall not record that.
That matter, your lordship, records after the report or affidavit is filed.
That will be the, yes.
Yes,
already.
because that it will be better. After those are on record, matter, then it will be easier for me and for your lordship as well.
But you have taken instructions, these two persons are under your control.
Yes. One is Group D staff, in HON'BLE, and the other one.
Uh,
Yes. Officers, officers, they are in office.
and, on the prayer
appear on the
Anyone
face
who
of
has
it,
done
it shows this is a tampered one, it's manufactured one, and the instruction is they're concocted. And who has done it? I don't know. Whether at the instance
That
of
you
some
have to
government
find it.
official, yes,
because
or
these
at the
mobile
interested
numbers
party,
and
some interested party.
maybe I'm not stopping you. Make inquiry investigations. I'm not stopping you.
Yes, yes.
Everything, some particulars are also being furnished. Signatures are there, and repeated
Yes.
these communications are being made.
The veracity of these complaints, the authenticity of these documents, those are in this, those are
You carry out your investigation. I'm not stopping you, but you should stop this. If it
Well,
demerits from your office, even otherwise, you being the state, you can deal with that.
yes, yes. If necessary, there will be further investigation into the matter as to who has done this. It may be the government officials, it may be some other interested persons.
Maybe.
They are litigating unnecessarily.
You to
Unnecessary litigations
investigate.
are there.
That is for you to
Find out.
to investigate. So other wing of your government may have to be.
Lordship.
Yes.
Lordship, great.
Yes, call the next matter.
May it please your lordship, this is for extension of interim
This is
order.
the matter which was heard by your lordship.
Matter- আরে আমি একটু বলি দাঁড়া তুমি বলবে ছটফট করছো কেন
ছটফট করছি তার কারণ হচ্ছে this was placed to lordship was pleased to direct
Well,
that
this is a matter where your lordship, my lord,
5th January.
Or order.
5th January, the order,
It is
but
not appearing.
it is gone down to as a hearing matter.
my lord, may I say this? Mr. Rai, my lord, comes from the respondent, my lord. He
No, for hearing.
is.
It was subject to
yeah.
question, my lord. It was placed. The matter was argued before your lordship at the stage of.
My lord, may I say this? এক second দাঁড়াও কতটা। My lord, may I say this? My lord, this is a matter which
But
your
the
lordship.
order records for hearing.
Yeah, for hearing. My lord, I've.
According to you, there was a mistake in recording that.
My lord, if there is a mistake, they ought to have come and my lord, seek
I was
corrections.
very good.
Yes, what is
My
this
lord,
matter?
this is a matter your lordship may kindly recall. This is, my lord, with regard to constructions of a place which was in a village called my lord, a local hut by the municipality on a PWD land.
Heart.
No, the place is a hut. But I constructed a place where the persons who come over that particular marketplace, they can have a public toilet and also a place to stay during the time where they usual in course of business they do it from since morning to evening. Now there was an allegation, your lordship may recall, that the private respondents say there is an encroachment on his property by the municipality. Now, I being a municipality, my lord, I at that point of time, way back, my lord, even a decades back, sought a permission from the PWD. I was given a permission to construct. This is a, my lord, part say, my lord, would come under the government's, my lord, Act 1899. Now, my lord, in so far as these allegations, my lord, would not come into or it may not be boiled down, since, my lord, there was a permission from the PWD department and, my lord, we constructed accordingly. However, at his instance, my lord, a proceeding was purportedly drawn under the West Bengal Highways Act. There were 2 rounds of litigations. They initially filed a litigations, a writ petition, whereupon, my lord, an appeal was carried on. And in the appeal, my lord, a direction was passed, my lord, to draw a proceeding in a section 10, in terms of section 10. Then again, my lord, a second round of litigation when came, and it ultimately went up to division bench. A finding was ultimately recorded, which, my lord, we also could not have a proper notice on your lordship's kind wisdom, my lord, and since it was put it on record that there was a paragraph recording that it is admitted that encroachments are made and constructions are being made without any authority. So during that time, while your lordship was hearing, my lord, for the extension of interim order also on merits, it was, although, my lord, verbally, my lord, considered by your lordship, my lord, this particular passage, my lord, may, my lord, ultimately, my lord, have some effect with regard to adjudication of this writ petition, because there has been a recording go in the respect that it is admitted. Now, my lord, after that, my lord, what happened, my lord, that division bench order, my lord, again, my lord, division bench also considered, my lord, then DM again directed, my lord, whether to see or not that there was a actual encroachment or my lord, how much and how far land my lord, was being there. Then my lord, the BLO report was published. Then they again my lord, went up in a my lord, writ petition by saying that DM did not have any authority without my lord, beyond the scope of section 10, that how much far or whether my lord, by encroaching that land, if any, whether such is going to be obstructed his egress or ingress. He cannot look upon that. I am not a learned single judge, my lord, held that yes, DM cannot look into. DM can only see under section 10 that whether there is an encroachment and construction. Then, my lord, again it went back. My lord, the adjudicating authority.
To the
Adjudicating authority passed an order, my lord, saying that yes, there is an encroachment and my lord, and constructions, which
who
was
is the adjudicating authority?
uh
Assistant engineer.
no
DM.
DM.
The appellate authority is
DM is the
No, no,
appellate
no.
authority.
Appellate authority is a DM. Adjudicating authority is the engineer.
So, yes, so it went before whom?
Before the engineer, PWD.
Assistant engineer.
My lord. Thereupon, my lord, it went in appeal. Then, my lord, in appeal, my lord, it was affirmed. Against that, my lord, we filed this writ petition, and there was a subsisting interim order since from the very beginning. Considering, my lord, there are other aspects, my lord, because in so far as my lord, acts are concerned, my lord, we say, my lord, we are a local body. Municipality also falls under the within the definition of state, my lord. Now, only the thing is that since there was a passage in the division bench order, which did not thereafter, my lord, interfere by my lord, in any way. So, my lord, in the meantime, what we did, my lord, we have already applied for a review. But that review has already been applied. The necessary application has been filed. This is on instructions. We have substantial record to show, my lord. We have made a request because original order passed by my lord, a division bench where my lord, only Justice Rao is available. And a bench is constituted by Justice Bhattacharya along with Justice Rao. The matter was mentioned in court number 16 also. File has been sent to that. And my lord, I am told, my lord, the Justice Bhattacharya, my lord, has said that as soon as, my lord, the bench may be constituted, the bench, my lord, the bench will hear. To that extent, particularly, my review is confined that this is whether it is admitted or not, we do not know, but there was no admission on our part that we made that encroachment or the alleged constructions. Now, for this purpose, my lord, what I say,
What is your right in the property?
my right
Even
is
without the admission.
my right in the property, my lord.
Whether there is admission, my learned senior friend argued in such a manner, or senior friend, that there is admission with the division bench. I'll satisfy your lordship, there is no admission. It's a special officer report based on which the division bench passed an order.
No, even without the admission,
My lord,
please show your right in respect of the property value of construction.
my lord, this is my right, my lord, so far the Government Grants Act is concerned. The state itself, my lord, in their affidavit also provided, my lord, such, my lord, omnibus provisions, my lord, that if the permission has been given, I can construct. There are two judgments on the same field, my lord, by Justice Senior Bhattacharya, my lord, sitting in a division bench. My lord, kindly take it up, my lord, after the review application, because this matter would take some time.
No, even without the admission, I accept your submission, there was no admission. That's the ground of review. I will clarify that.
Well, I thought that you lordship would give me a 7 days or 10 days time, come back after review. Then I have not brought on the earlier day, my lord, I have brought, but to be very candid enough. Because I said, my lord, but I would not take much premium, my lord, because on a just and proper ground, give me a limited protection for 15 days. I would come back. Whether the review goes in my favor or not, I would argue on the point, my lord.
Can you turn to page 41 once? Page 41, the admission. What is the admission?
41.
Yes.
Well, that the division bench order. That is.
Subject matter review.
41 of the
Read application.
yes.
This is the order, my lord. Kindly come to page 45.
I have not said anything.
Last part, one paragraph.
The admission, I want to find out the admission portion.
তুমি আগের দিন এটাই তুমি দেখিয়েছিলে।
The council, page 44,
Your Lordship may kindly, in compliance of the order passed by the Honorable Singh Judge, my fund and the middle portion. The Assistant Engineer Highway Division has issued the notice to the appellant 23rd March to directing the municipality to remove the said structure obstruction to the satisfaction of the highway officer on or before 20th April 2021. The counsel of the appellant for the submit. This is the appeal by the whole municipality itself. That the assistant engineer, without giving a so-called notice and opportunity of hearing, issued an order for removal of obstruction. The counsel for the respondent submitted that the appellant had made construction without the approval of PWD. Admittedly, land belongs to the PWD. The allegation made by the petitioner has confirmed by the report of the special officer. It is crystal clear from the report that the appellant has made illegal construction over the PWD, due to which ingress and egress of the petitioner has been stopped. The counsel for the respondent further submits that the statutory authority cannot challenge the order passed by the statutory body, as the municipal authority has made illegal construction over the PWD, and the PWD intends to clear the illegal construction over the disputed land, but the appellant is not ready to remove the illegal construction. This court has considered the rival submission of the parties and materials available on record. It is admitted that the municipal authority had made construction over the land of PWD without the permission of PWD. The said construction is restraining the egress and egress of the petitioner. The report of the special officer supports the contention of the petitioner as well as the PWD. The Honorable Single Judge, by considering the report of the special officer, has only directed the authority to initiate proceedings under Section 10 of the Highways Act to removal of the impugned encroachment over the property in question. The PWD land acted on the order passed by the Honorable Single Judge. This court not found any illegally with the order passed by the Honorable Single Judge, and there is no merit in the appeal held by appellant. So this was the sum and substance. Now I'll turn to the next page, page 47.
Yes, Mr. Rai, I'm extending it for a limited.
Malad kindly consider this was coming from, it is not a fact which is emerged newly, or it is.
Mr. Rai, when a review application is.
Malad, whether it is, even if Malad kindly consider, there is no review. This order, Malad kindly, whether the any right.
That I can, Mr. Rai, that's
the right.
You are spending.
Review, irrespective of what I put this question to myself. Regarding that findings, even if today, my lord, this order which has been challenged before your lordship.
I'm recording your submission. I'm giving them a limited time because it has to be hard. Today now it's under the heading extension of interim order.
My lord, it was hard.
The interim order is till 31st.
No, till tomorrow.
So if my lord Kali,
15th of January.
That is why my lord has fixed to fix this on 5th. My lord, can recall that, and it was interim order extended till 15th. Otherwise, my lord, that is why. Be as it may, I'm not disputing the same. Now, my lord.
I'm extending it for a limited period. I'm recording your submission that it has no bearing on the review application. I'm recording your submission, but since a review application is filed and this matter is to be heard, this is under the extension of interim order. I'm keeping it on a day, as you have said, under the heading.
Four orders, my lord. Four orders.
Four.
Otherwise, my lord.
Both of you will be citing many judgments.
I'll not cite any judgments. No, only the what is there.
Mr. Basu will submit.
Mr. Basu, yes, certainly, my lord.
You may not have anything in your support.
In respect of my lord,
You don't have anything in your support.
My lord, who is the owner of the land? The state. What is the stand taken by the state?
Yes. State, my lord, already the order has been passed by the 10-2 authority, and appeal has been affirmed by the
And the state in its affidavit say under the Government Act it is permissible, and they under the Government Act says that it requires a permission.
So sue the government.
Sue the government.
Being the authority, local body.
You have suffered. Please sue the government.
What damages?
You know, you can advise your client how to proceed against that. Ashun, this matter is appearing under the heading
Extremely grateful.
If I had proposed 30th, you would have said not 30.
Extremely grateful, my lord.
Yes. So what is the can for? And what is the can one for?
Can one, man, it's for which year, my lord? Which year?
2022.
I think, my lord, it's possibly their file. But the possibly, my lord, they have
One bar করুন তো।
can want to bar করবেন? Well, may I just take? They have initially challenged the order of the passed by this granting interim order in the division bench. The division bench.
What is the can for?
Yes, may I just?
Whether anything survives on that can.
Otherwise, your lordship would কিসের
Yes.
জন্য আপনার কাছে নেই?
Dated 6th of September 2022.
Yes, that is the original interim order passed. If possibly it was not recalled, they appealed, appeal dismissed.
So this has can 1 of 2022 টা order record করে দিন। Yes, item number 6, who is appearing? Yes, Mr. Mishra. Yes.
Appearing for the statement.
Encroachment of public road. Yes, Mr. Mishra, have you served upon the respondents? Private respondent served. Yes, madam, what is your instruction? You are for the private respondent?
No, state.
State. Yes, what
My
is the
lord,
instruction?
my lord, I would seek some instructions in this regard.
Yes.
But if your lordship come to page 21, 26, 25, the representation by the petitioner to respondent 3, 2, 1, 4, 5, 6.
Yes.
I'm concerned about 3 only. Then let let it be considered and by giving an opportunity being heard of. And let the writ be disposed of.
Ashok.
Lordship, in the meantime, Lordship, the assistant engineer directed the BA.
Demarcation.
Demarcation. না একটা দিন কপি একটা কপি আছে আমাদের দাও একটা
Ashok.
My lord, what is that? I have not any copy. Yesterday brief has been allotted, my lord. And my lord, kindly direct him to serve me another memo.
Please give a copy.
Photocopy. Court
Okay, call the next matter.
Grateful next.
My lord,
For the state
Yes.
lordship.
Yes. You're for the state.
Yes,
My-
lordship.
Yes. Yes, Mr. Misro.
Allegation is that the public land has been encroached for the highway. And the
Yes,
Lordship, same lordship, representation, kindly come
any,
to page
Mr.
4.
Misro, any demarcation, no notice has been. What is your instruction?
Lordship, this is a report from the police station, Nandagram police station.
Station is nothing.
Yes,
Ashwin,
lordship, and
uh,
representation is there, lordship, can it be considered by the appropriate
petitioner
authorities,
claims to
page
be the
34.
owner of. Service
Service has been completed.
completed.
Same
This is
matter.
also same.
Same matter, lordship.
Any demarcation, any memo has been issued by the
No memo has been issued for demarcation.
Ashwin. Evidence service record. Mr. Misro, learned advocate appealing for the petitioner submits that the private respondents have been duly served. First, in spite of service, none appears for the private respondent. First, petitioner claims to be the owner of a plot of land being Dag number 1227/2869, jail number 154, police station, Bhupati Nagar, within Moja Bajkul in the district of Purbo Medinipur. First up, the petitioner states that a PWD road is running adjacent to the aforesaid property of the petitioner. First up, the petitioner alleges that the private respondents have erected a construction by encroaching upon the PWD road just in front of the aforesaid property of the petitioner, thereby obstructing the ingress and egress of the petitioner from his property to the PWD road. Mr. Petitioner submitted a representation before the representation dated. Where is the representation?
Representation dated, Lordship,
19/7,
assistant engineer, Lordship,
19/7/2025.
Page.
Page
is
22.
22.
Submitted representation dated July 19, 2025 before various authorities including the Assistant Engineer Kontai Highway Subdivision Public Works within brackets Roads Directorate Kontai.
Lordship, that would be the, Lordship, the 26. Contact would not be there. That letter has been communicated. He is the competent authority. 26, Lordship, assistant engineer, Tomluk division, PWD roads. 26 and 25, executive engineer, Tomluk.
So, Tomluk, he is the appropriate authority,
Lordship,
including the
25 and
assistant
26
engineer,
representation. 4 and
including the assistant engineer, Tomluk Highway Division, Public Works within brackets Roads Directorate, Tomluk. First up, Mr. Misro, learned advocate appearing for the petitioner submits that in spite of receipt of such representation, no steps have been taken by such authority to remove the encroachment from the PWD road. First up, the learned advocate appearing for the state submits that necessary steps for removal of encroachment shall be taken if it is found that there has been encroachment upon the PWD road. First up, in the light of the submissions made by the learned advocates for the respective parties, WPA number such and such stands disposed of by directing the assistant engineer, Tomluk Highway Subdivision, Public Works within brackets Roads Directorate, being the fourth respondent to consider the representation of the petitioner dated September 24. ওইখানে না জুলাই বলেছিলাম আগেরটা কোথায় দেখুন
And I am appealing for the petition. Lordship, the land has been acquired for the purpose of installation of the project implemented to the Nondigram, the Bach school.
What do you want?
Lordship, I am praying for compensation and land loser certificate. Still now it has not been demarcated, it has not been issued land loser and compensation. I made the representation before the competent authority.
Southeastern Railway, where is the service?
Lordship, service has been done.
Who is appearing?
I have served it, Lordship.
Served.
Lordship, that accepted it. The central government, Lordship, the Garden Reach, Lordship, the general manager is the competent authority, Lordship. The competent.
Yes, who is appearing for the state?
The state is not involved, Lordship. The only for BLRO for demarcation, railway, central government, Lordship. Respondent number 3 is the.
Who will issue the land loser certificate, Mr. Mishra?
Chief Lordship, respondent number 3, Chief Administrative Officer, Construction, Southeastern Railway is the competent authority. The hearing would be held by.
Who appears for Southeastern Railway? देखिए फिर सर्विस तो देखिए Item delivered to Kharagpur Technology Delivery Center.
Lordship, the
What is
guardian
that?
said accepted it, Lordship. The another sector is Kharagpur, Lordship. The
But it
guardian
was not addressed to Kharagpur
Lordship,
Technology Center. Union of India, there is
Sharply, Lordship. And Divisional Railway Manager, Southeastern Railway, Kharagpur. It has been already served. The General Manager, Lordship, has been served.
railway authorities. Who appears? Usually appears for railways.
Even nowadays, the Union of India is representing the railway.
Union of India. So please serve upon the advocate on record of the Union of India.
Only one government.
Not accepting it, Lordship. I have served.
One ministry, one budget is same, Miller. The Union of India is
But the railways, I think there is a separate
No, there is
panel.
no separate.
No separate panel.
Nowadays, the Union of India, the advocates are representing.
I think there's an advocate on record or something by that name.
Central government advocate.
Central
There is
gov-
10 group.
The petitioner
I am for the
10,
petitioner.
yes.
This is with regard to, my lord, the illegal, my lord, encroachment over the PWD road, my lord.
Yes.
Page 58, my lord, my lord, my complaint before the, my lord, the assistant engineer Canning Highway Subdivision.
There's a report filed by the police. The police requested the video.
Police, yes.
BLRO, you logically see the annexure.
BLRO has given a report.
No. BLRO, police have requested the BLRO to demarcate the land.
You have requested.
Ideologically, annexure.
Annexure.
Please.
Oh.
Next, annexure. Okay. Report filed by the police, annexure. Already.
No, PSI has requested.
Yes. Demarcate the land, my lord.
PSI has no authority under the Highways Act.
With regard to, my lord, the
Yes, have you
service-
served the private respondent?
Regard to service, my lord, that was booked on, my lord, on 13th of, my lord,
What
January.
is the service
দিয়ে দিচ্ছি নামটা দিয়ে দিচ্ছি
I am appearing for advocate.
you are for the petitioner? Yes.
This is my affidavit, sir. The petition before lordship lord purchased 9 decimals of land, lord, beside the national highway 19, lord. That is Durgapur, Kolkata Durgapur Expressway.
Compensation.
Compensation, my lord.
Yes, Mr. Bandyopadhyay, what is your instruction?
No instruction I have received, my lord. Yesterday evening I have received the brief. His, my lord, allegation is this, my lord. The National Highway Authority, my lord, encroached his land and constructed the road. He
Just
made
said
representation.
acquisition. Just said acquisition, no compensation.
No compensation. There is no acquisition, my lord. He has, my lord, obtained the, my lord, the information by RTI. RTI, my lord, the SPS, Special Land Acquisition Officer, will inform that plot of land is not involved in the case. He made representation before the National Highway Authority, page 41. National Highway Authority কই?
সেটা কি আপনার সঙ্গে
আরে ন্যাশনাল হাইওয়ে আমি নাকি?
না সেটা ঠিক আছে।
What is your plot? 98.
Yes, my lord, the LR plot 98, RS, my lord.
LR is 98. Mr. Bandyopadhyay, where is it has been said that it is Special Land Acquisition Officer? Drawn to the in response subject.
Hooghly, my lord.
Found that the subject plot is not
Miller,
involved.
page 53, Miller.
Neither in any disposed of nor in any ongoing LA case. Your property is not involved.
Yes.
So, my lord, that is after at the time of making flyover, my land has been taken from.
This is the report. How do you dispute this?
Not physically, my land has been acquired, my lord, by the National Highway Authority. Therefore, I have come.
Petitioner purchased the land in the year 2017. I don't know, my lord, when the land has been acquired or not.
No, but just it says, Mr. Bandyopadhyay, it has not been acquired. You should have
Yeah,
said that it
yes,
is.
my lord.
So
It is not involved in the any LA case.
So then the date of his purchase is immaterial.
Yes, my lord.
If you
He
have
made
said yes,
representation before the
after
National
acquisition,
National Highway Authority, my lord, take decision, my lord. If your lordship desire, my lord.
They have
have you served upon the National Highway?
Yes, my lord.
National Highway.
I have received, and then that has been confirmed, sir.
দেখাও সার্ভিস করেছো তো দেখাও এফিডেভিট সার্ভিসটা দিই
Where is the record of rights? Where
That
is
is
your property?
Page 30.
আচ্ছা আচ্ছা
Record of rights is there.
Yes.
Page 36.
36.
Yes.
ওটা ঠিক আছে
Your share is 9 decimals.
My lord.
আমাদের কিছু বলার নেই
It also stands in your name.
My lord,
Does not
there is-
appear it has been utilized.
My lord, at the time of constructing flyover, ramp, they have forcefully taken possession of my land. Therefore, I am entitled to compensation.
The petitioner alleges
my lord, disposed of.
Disposed of.
Let
Item number 12.
I'm praying for short passover, my lord. The matter is going on, my lord. Court number
What is this matter?
two. Fact, my lord. The one here, my lord, I'm challenging the DM order, my lord, passed.
Where is that order? Impugned order?
Page number 81.
Started from 81.
I started from 81.
81 it starts. What is the effective order?
Effective order is page 89.
89.
This is an appealable order in terms of Rule 51 of the Minor Mineral West Bengal Minor Mineral
After
Concession Rules.
expiry of the lease, no extension or renewal will be granted. That is the final decision.
এসে গেছে যার অ্যাকাউন্টে 500 চাইছিল সে এসে গেছে
Where is the new rules?
দিয়ে দাও কপি দিয়ে দাওনি দিয়ে দাও
So this is the 2021 rules. And also this lease was granted in terms of 2016 rules. So remedies before the divisional commissioner, also Rule 51 of 2016 rules.
These are the concession rules.
Yes, the lease was granted in terms of this rule.
Concession rules.
So remedy.
This that lease was valid till
23.
2023.
Yes.
So in the meantime, the new policy has come into force.
Policy followed by these rules. Policy came into effect in July 2021 and this rule became effective.
2022.
Yes, January
What is the
2000.
provision for extension.
See, there is no provision for extension.
And what is the method of issuing this lease? Auction?
Yes,
Where is
auction.
that?
This is in 2016 rules. It is for
16 rules. Rule?
me just.
আমাদের তো 2016 রুলসটা আছে Yes, there is a provision of appeal.
That divisional officer.
Commissioner, divisional commissioner.
Commissioner.
But I am guided by these order passed by these honorable High Court worker in which similar situation has been occurred, and these honorable High Court granted by setting aside and extended the lease period. If your lordship kindly see for a moment the page 9. The renewal has been extended for that reason. But 20, serial number 20.
কি মামলার নাম কি?
Basudev Pal.
কেস নাম্বারটা?
Case number 2088. Serial number 20, my lord, respondent number 45 are directed to allow the requisition and renewal application dated such and such forthwith and and further directed to execute a registered deed of specific direction has been made by these honorable High Court.
পয়েন্টটা না ডিভিশন বেঞ্চে জাজমেন্ট আছে তো
অন্য পয়েন্টে
Order passed by this division bench order. This order has been passed. Serial number 16.
Serial number?
16. page 8. As per the order passed by this division bench order, this order has been passed.
No.
Judgment of
Where is the
2018.
decision on the availability of the alternative remedy? It has not been taken into consideration.
Your Lordship, one thing I find that these
So if that was not
2002
raised, there's an
rules
appeal
section.
provision.
No, this is
Make
in
all
the-
those submissions there.
Lordship, this was in respect of 2002 rules where there was a provision for one-time renewal for another 5 years, which is not there in 2016 rule. Lordship, kindly come to Rule 38, which says
This was as per rule 2002 rules.
Yes.
that rule has been repealed.
Repealed in 2016.
Yes.
And 2016 rule says that
Initially, your lease was when?
Initially, my
14th November 2018.
husband's
18.
name.
14th
November 2018.
18, after coming to post of 2016 rules.
Oh, so that was the now it was valid till
2023.
2023.
Yes.
So was there any provision for renewal in the lease?
No.
deed?
No.
So is there any provision for renewal in the 2016 rules?
No. 2016 rules and 20 after 21.
So your lease is guided under the 2016 policy.
Yes.
If that rules do not contain any provision for extension, your lease deed also do not contain
They
any
your
provision.
Lordship directed the respondent authority. I directed, I will file within a certain time.
What?
I will file the
Appeal under section 51.
before the
I think
authority.
that's better without going through
Before the
this.
authority concerned.
And your Lordship wanted to know that mine is an auction, Rule 38.
Rule 38.
No, your Lordship wanted to know that where is the provision for.
If she wanted to press this on merits, I would.
At the very outset, I said that remedies before Rule 51.
I think it's better go before the.
Within a certain time and kindly direct them that are dispose of within a certain time.
There is
Before
30 days from the date. Lordship, kindly condone the delay. We will not stand in the way regarding condonation. This is 30 days.
Even after the period specified, if the applicant satisfies the appellate authority.
Yes.
So the power is there.
Yes.
Power is there.
Power is there. The order was passed when?
Order passed.
The ultimate order is when?
30th October
That is
2023.
30th October 2023.
2023. And this writ petition filed on
25.
26.
In the meantime, the husband of the petitioner died. For that reason, he did not apply before the any authority before the appropriate authority. For this, I annex the death certificate also. Minor child is there.
ঠিক আছে আর তো বলতে হবে না
Though the writ petition
paid.
Every service.
Lordship can keep the 2021 rules.
Hey, 2021 rules টা
ওই রুলসটা
ওটা আলাদা ফাইলে রাখুন। ওই অর্ডারটা ওনাকে ফেরত দিয়ে দিন, ওরা অন্য মামলা may require it in other matters. Yes, call the next matter. Number 30. Yes.
Here also similar for Millard, that is, I am for the state respondent. Here also Millard prayer for extension of long-term leave.
Under which
And Millard order was passed. Lordship, kindly have a look to page 26.
Yes.
That was rejected by.
It was granted under which rules?
2016.
2016, same.
Same. But you
Yes, what do you want?
Here, my lord, the hearing.
It's an appellable order.
Absolutely, my lord. May I? My lord,
You want to move on merits?
No.
তাহলে একই order pass হোক।
Page.
For an appeal.
Absolutely, but delay, with regard to delay, that has.
What is the reason for the delay?
My lord, hearing conducted in 2023.
Yes.
No order communicated. I approach your lordship. Your
When it
lordship,
was communicated?
my lord, 26th November 2025.
All right. 26th November 2025.
24, page 24.
তুমি কারো এ-
With three.
26th
Mineral
November,
development.
yes. There's a document also to that effect.
Lordship, pursuant to the order passed by your lordship, thereafter the order was communicated.
23
So-
hearing was conducted.
Order dated 5th December 2023. That is the
কুড়ি হচ্ছে।
ওই আগে
এটা দিতে
ওইখানে yes.
My lord, this matter is relating to water connection, my lord.
Water connection.
Water connection.
Mr. Banerjee is not supplying water.
No, from the panchayat. No, from KMDA. But no, whether this will lie under group 1, my lord, kindly ascertain, because allegation is in the panchayat that they are not giving him the free access
My
by
lord,
way
he
of
is the private respondent. My main allegation is against respondent number 6, my lord.
Who is 6?
My lord,
they are obstructing.
Kanchan Ghosh, they are obstructing. My lord, we have applied for the permission. It has been
It was applied for permission from whom?
KMDA.
MDA.
Kolkata Metropolitan Water and Sanitation Authority.
Page 16 to 18, my lord.
How does it fall within
Land
group 1?
হবে এটা land হবে না তো
It,
land
yes, my
হবে
lord.
না
It should fall in group 9.
group 9 বা group 5 panchayat panchayat হবে এটা
My lord, in that event, my lord, liberty may be granted to collect the presentation form.
The learned advocate appearing for the petitioner
I am for the state respondent.
Lord 15, my lord, I am for the petitioner, my lord. Everyone has been served, but my lord, I cannot affirm the
Debate service not affirmed.
No, my
He's
lord.
tried it in course of this day.
My lord,
Everybody has been served.
private respondent appearing, my lord.
Instructed to appear on behalf of the respondent of 5, my lord.
Yes, yes.
My lord, the petitioner and the private respondent is the member of a particular cooperative society, my lord. My lord, the petitioner was allotted with garage number 4 and the private respondent was allotted with garage number 7, my lord. That too a resolution was allotted,
Garage.
my lord. In respect of, my lord, kindly see page 20, my lord. My lord, serial number 4 and serial number 7.
Who are you? You are?
I am the petitioner, Ashit Mondol, my lord. Ashit Kumar Mondol.
So, Ashit Mondol, you are allotted garage number 4.
And Vishnu Poto Saha, my lord,
Oh,
was allotted
Naam
garage
likhe
number
do.
7.
Yes.
My lord, thereafter the resolution was taken by the, my lord, cooperative society, but subsequently, my lord, the private respondent proposed me to interchange this said garage, which I refused, my lord. That is at page 23, my lord. I refused by a written letter, my lord.
Yes.
Subsequently, my lord, this garage was allotted by the Secretary Tagore Cooperative Housing Society Limited on 23rd of April 2024. That is at page 20. That
Page
24. The garage number 4 was allotted to me. With a sketch map also, my lord, the next page.
Yes.
My lord, thereafter, my lord, I made a prayer. What he has done, my lord, the private respondent started keeping his car in the garage, my lord, without informing me anything. And when, my lord, I asked the secretary of the said housing cooperative, my lord, he wrote to me, my lord, kindly please, page 26, my lord. 7/2/2025, my lord, kindly sees, with reference to the above mentioned letter from your advocate, I wrote to you, I would like to inform you that as a secretary of the said society, I have done my job to allot the garage to the individual concerned, as decided in the general body meeting. The dispute referred in the above mentioned letters between you and Sri Vishnupoto Saha. Therefore, I request you to settle the issue amicably if possible. Otherwise, you are free to take legal recourse as deemed fit. Thereafter, my lord, I submitted, my lord, I served a legal notice. There are also no action taken. My lord, lastly, my lord, the petitioner also at page 33, my lord, he served a representation, my lord.
Page
33, my lord.
Before
the Assistant Register of Cooperative Societies, Chief Executive Officer NKDA, officer in charge of the Newton Police Station, and the Secretary of the Cooperative Society.
My lord, pure question of law, my lord. If you also already passed order to the, if the cooperative matter, the dispute between the cooperative matter, the register of cooperative matter, the appropriate authority. I have gone through your lordship judgment, my lord. This cooperative has not been made party. Register of cooperative has not been made party. Apart from this, my lord, this will not come under the jurisdiction of the land.
the cooperative also I have.
Oh, cooperative. Then, my lord,
It's a
the
private
register of cooperative society is required to be made party first. If the dispute and the dispute resolved by the register of cooperative, then he has to apply before the register of cooperative, as per lordship judgment, my lord.
Yes.
Well, yes, my lord, what garage bar space he is claiming, but they are actually allotted to me, my lord. Kindly have a look. Resolution and my lord, my letter.
এখানে পুলিশ সেটাই লিখেছে যে এরকম একটা ডিসপিউট অ্যারাইজ করেছে।
Well, I have obtained a report from the police authority. One lordship kindly produce the report.
Mondol is 7.
Hey.
Yes, my lord. But he is
The
claiming my lord
resolution of
to the 23.
Cooperative আছে এখানে যদি।
2023.
Yes, my lord.
Resolution, my lord, 1st of April 2020. Page 7.
1st of
April 2020.
which page?
Page 17 onwards.
First of April. This is of March. The previous resolution.
Page 17, 1st April, my lord.
My lord,
Page
1st April. But he is forwarding 29th of March 2023.
that was I think that was a verbal one, my lord.
No, in writing. Please give a copy to him. Do you have an extra copy?
No, my lord, I have.
All right, so you make a representation. Do you have the copy of the Cooperative Societies Act, Mr. Dotto? Where is the provision? Any dispute between the members. So it's a dispute between the members. Its registrar has to decide.
The matter is to be referred before.
Has he made any representation to the registrar?
No.
Assistant registrar I have made, man.
You have made a party, but have you made a
My
representation?
lord, I have made my lord page 33.
Which section, Mr. Dotto?
It's well, possibly section 21, my lord, possibly. Okay.
100, I think 100,
কত নম্বর?
102. Disputes to be filed before the registrar.
102. 102,
102.
99 onwards, my lord, 102, my lord, specific section.
102 is settlement of disputes.
Yes,
Any
my lord, specific
dispute
section, my
concerning
lord.
the management or business of the affairs.
Right from section 99 to, my lord.
Disputes. Only election is being taken away.
Any dispute, my lord, you lost to decided the issue, that any dispute relating to the touching the property. West Bengal Cooperative Society Registration Act, 2006.
102. Yes, sir. What do you say?
102.
Eta din.
I have an occasion to argue with you in this matter, my lord. রেজিস্ট্রার কাছে অ্যাপ্লাই করে এটা একটু রেফার করে দাও, লিভ নিয়ে এখানে করে নাও।
The secretary cannot decide this.
No, my lord, we have made representation before the assistant registrar Hardco building.
Where is that?
My lord, page 30.
Hatco.
হিটকো,
Hitco. Sorry.
হাটকো আলাদা আছে।
My lord.
Where? Which page?
Page 33.
Page 32 is
33.
Copy 2.
33.
33. Oh, assistant registrar of cooperative societies.
That matter, this representation.
Directing this to
Yes.
directing the registrar to decide this.
Yes. To resolve the further protected cost of litigation, only lost to kindly direct
the petition. Yes, what is this?
Taking compensation and it be neutralized for the purpose of making construction in 2015 and advertisement was made. Pursuant to that, I made an application. Thereafter, no years.
Direct purchase.
That was the proposal.
Where is the proposal for direct purchase?
Now it appears at page 18.
Page?
Page 18. And it's equal to. Left hand top.
Right. It has been utilized.
According
Mr. They where is the policy?
according to him, my lord, that is, if your lordship will come to a page one order was passed, my lord, before that.
Yes.
Similar order. As because, my lord, whether that is utilized or not, that will be considered first.
No, Mr. They, what is your plot?
That plot was not in this. That clause was not included in this, my lord. And application is.
It appears at page 70.
Page 70. What is your plot?
159.
159. Where is that in this notification?
That 159 is not in this notification.
Then
But in 2017, an inquiry was held and a list has been prepared. I have given the memo number wherein my name is appearing. I have given the memo number.
Where is that? Page? Which page?
My lord, page 21, he filed an application.
No, he says there is a memo which refers to his plot. Where is that?
Page 8. Sorry, page 6, paragraph 8. I have specifically mentioned where my name is appearing.
Page 6, paragraph
8. That this has come to the notice of your petitioner that by the memo of the list of eligible landowners were sent to the secretary.
No.
For raising compensation.
Please show me that your plot falls within this notification.
192, 159.
Does it fall within this notification at page 18?
No, ma'am.
No.
That I have seen, ma'am. Kindly call for a report.
So, according to you, the list of eligible landowners.
Yes.
Yes,
My lord,
Mr.
if filed an application before the authority will consider.
No, but he has made a specific averment at
Whatever may be that averment is not sufficient. My lord, that is a
please file a report to that. What is your
report.
stand?
My lord, if he wants
Produce
to,
this report.
my lord, I would, that is, if they consider, my lord, before that, my lord, if they filed another application, my lord, and that was considered by the authority, and my lord, page 28, my lord, and order was passed. Yes, my lord. An order was
28 is an order of the court.
Yes, my lord, order of the court. I pray, my lord, that your lordship pass that order. That is we consider that aspect. If he is in that category, my lord, he will get the money. As because our notification is that we purchase that.
Mr. Dev, please kindly come to page 29.
Yes, my lord.
There the submission was that has denied and disputed. He submits that the land has not been utilized, but the state wants to purchase the same under direct purchase policy in terms of the notification at page 21. Is it your same submission here?
Yes, my lord. If we wants to take that land, my lord, we must.
Here he wants, the state wants to purchase the land.
If,
that's we also specific.
If we utilize, my lord, then we purchase the land.
No, has not been utilized.
Then, my lord, that is not our submission.
That was the submission there.
For that, my lord, your lordship can pass the order.
But
That is
please take instructions whether his name appears, because he has made a positive statement here on oath.
My lord, if his name is appeared, my lord, he will consider and he will get the money. As because, my lord, notification is that, my lord, we have purchased the land, my lord.
He wants to know whether his name is appearing. Please take instructions on this, whether his name, he has given a memo number. You can produce that memo to show whether his name appears. If it appears, then we'll pay compensation, take instructions, whether he's entitled to or that.
Yes, my lord.
The petitioner
জমির মালিকানা সপক্ষে যথোচিত নথি সহ কাদা কাগজে নিম্নলিখিত ঠিকানায় বিজ্ঞান প্রকাশের দিন থেকে 15 দিন আবেদন করবার জন্য আবেদন করা হচ্ছে। Now, my lord, they filed an application. Now we consider, and my lord, if we take that thing, my lord, we must take the thing, my lord, by direct by purchase policy. That is the Jomir Malikana, that is the my lord, according to the
Accepted, but Mr. De, prior to taking a decision on that, can you utilize?
my lord, that is
Because
the
there are two procedures, Mr. De. If you take a property of a citizen, you have to either
my lord, that
initiate
is
a proceeding
that
for acquisition.
that is an my lord, we give an offer.
Yes, you give an offer, they may accept, they may not accept.
Yes, my lord.
Let us assume that they have
Now, my lord,
accepted. Let us assume they have accepted. Let us assume, I will give two versions. Let us assume they have accepted.
My lord,
then whether prior to paying that purchase policy, prior to purchasing, can you utilize? This is my first query to you. And second option.
my lord, that is another thing, my lord. My lord, that is when we acquire on another thing, my lord, that is
This is not acquisition, this is direct purchase.
direct, my lord, that is we give a offer. We open offer was given to everybody. The please, this is the land. We want
Some
to take
may
this
accept,
land.
some may not accept.
Yes, my lord. If
Yes.
anybody accept, my lord, we take that acceptance. He filed an application, my lord. So, my lord, we must consider that. And if we take that land, my lord, and if you utilize the land, we must give them money according to the that is the my lord offer. Big Gopti. 29 for the petitioner, my lord.
Yes.
What will kindly come page 25 representation.
Page
25.
25, yes. What is your representation for?
Presentation for particular land has been acquired for construction of the water tank in the area.
But no compensation.
I'm not taking any compensation, I'm taking a temporary job.
You have got a temporary job.
Before completion of.
Mr. Dey, you are appearing.
Yes, madam.
Any instruction?
Yeah.
What do you want?
Vertically come page 25.
25. Consider this.
Yes, madam.
The petitioner alleges yes. Mr. Dey, you are appearing.
I am appearing my lord, for the state. Your lordship directed Mr. Shuddhoday Badok to take instruction from my lord WBI IDC. But I have been told that he has lost his father day before yesterday. called him. He says for pays for 2 weeks time to come back and report to your lordship.
What do you say?
No, my lord. In
Uh,
case, my lord, I shall not.
Any junior of his is present?
Lordship, I am for
Oh, you are his junior. Such and such learned advocate. Instructions and other things so that I've given a longer time for that. Yes, call the next matter.
My lord, under the same heading.
19
Under the same heading. Yes, yes, under the same heading.
And 19, Mr. Taposh Bhattacharya is for the petitioner, my lord. He called me and informed me that he has some difficulty to
Communicate
he-
that order.
he
Face the
requested me.
consequences in
I have to face. Immediately I go back and I face it.
Yes,
And
he has not come.
he has not come.
Not come.
Yes.
And his son is also not there. I am to get the instruction. I
have to file a report, Mr. Banerjee. Where is the report?
Report is there, my lord. Report
File it and give a copy to him.
Fine.
Give a copy to him.
Fine.
This is for initiating the direct purchase.
Direct
policy.
purchase, but I would be praying for some positive direction from my lordship. There's a difficulty, but I will just explain, my lord. There are several authorities, my lord, who are to do it. LA has taken the decision that direct purchase has to be done. It went to the, my lord, superintending engineer, State Highway Circle. Now,
give a copy. Let Mr.
they are saying that there is some, my lord, discrepancy so far as, my lord, the measurement of land is concerned as per their actual field measurement. They requested LA again not to do the correction. No, that correction is not done. That is why they are not initiating. My lord. So, my lord, lords, I will be requesting a lordship not to give specific direction to LA as well as to them to complete it.
Give a copy to Mr. Bhattacharya.
My lord. They have explained what are the steps
When
to
he
be
will be
taken.
available.
He said only not today.
Only
I'm
not.
giving a copy.
An accommodation has been sought for on Calculate item number 1. Item number 207. Yes, you are for the petitioner.
No, my lord. I am for the Howrah Zilla Parishad, my lord.
Who is for the petitioner? All urgency at the time of mentioning. After that,
Mostly this has also been mentioned or upgraded, my lord.
that is why I am saying
my
all
senior
urgency at the time of. This matter was mentioned, citing urgency.
টু PM ফিক্সড হবে না?
Same order, dismiss for default, শুধু হাওড়া জেলা পরিষদ হবে না। Yes, next. Item number 302. Same order, dismiss for default. Next. 323.
হ্যাঁ, ও আমার বিটটা ওইখানে না, তাই খুঁজে পাচ্ছে ঠিক আছে।
Same order, dismiss for default. Next. 156.
I'm for the petitioner, my lord. My lord, national highways, the notification of acquisition of land. Petition of an interested person, they applied and award has been passed. But they did not pay the entire amount. 50% of the set has been paid. The given of the petition, my lord, that under section 3,
Yes, where is Mr. Chondi Charonde? Where is Mr. De?
on the date when I handed over a copy of the petition within 1 hour.
Sina, can you call Mr. De? Yes, yes.
Now, my lord, kindly see, National Highways Act, section 3E. 3D says 3E and 3H.
Highways Act.
Highways Act, my lord.
National Highways Act, yes. Section
3E. Power to take position.
Yes.
Where any.
Oh, where, whether it's before or after that issue.
After, my lord.
Yes, that issue.
Yes, my lord.
Yes.
Where any land has vested in the central government under subsection 2 of section 3D and the amount determined by the competent authority under section 3G with respect to such land has been deposited under subsection 1 of section 3H with the competent authority by the central government. The competent authority may by notice in writing direct the owner as well as any other person who may be in possession of such land to surrender or deliver possession thereof to the competent authority
or any person duly authorized by it in his behalf within 60 days of the service of notice. Then your Worship can see 3H. Deposit and payment of amount.
Please give me a minute.
Deposit,
Please give me a minute.
Deposited.
Then possession to be taken.
Lordship. Another point is the my lord, can you see B explanation? Something B explanation.
B explanation, yes.
Yes. After B explanation is given, that is something my lord helpful for the state for the state government. That is, it is say my lord, say the authorization limits revolving in HR are explained with the help of an illustration as under. Say the amount of award is rupees 2 crore, for which the CALA places demand on the acquiring executing agency. The executing agency shall issue an authorization in favor of CALA to draw an amount of up to rupees 2 crore from the central account in limits of rupees 50 crore at a point in time. As the CAA keeps disbursing the amount, the limit of rupees 50 crore shall keep getting automatically recouped and so.
So in installments, this 200 crores
Yes,
will be
madam.
deposited.
Yes, for installments. Yeah, in our case, 50% hasn't paid. That may be said as installments. That is the only point. But we are entitled to get the entered amount. Before disbursing the entered amount, they cannot ask us, yes, quit and vacate the position. That is the only point. But another one, my lord, I don't want to suppress before lordship. A civil suit was filed earlier occasion, so it's in cause of action
Civil suit against
these respondents. Against these respondents.
Against respondents.
Yes, my lord.
Then what
Now,
happened?
liberty was given to file afresh. They filed the suit before the another junior division to senior division due to peculiar jurisdiction. But in a senior division, according to client value, they pay for liberty to file afresh. But learned just says no liberty was there, therefore withdrawal is allowed without giving liberty to file a fresh one. But our High Court judgment is there on this point that if liberty is given, they cannot split. If somebody says,
then you have to challenge that order. You have to challenge that order.
That is a difficult. I have not suppressed anything before.
Unless you challenge that order is in force, binding, staring at your face.
That is the difficulty, my lord. Whether I have to challenge the order, or this honorable court has ample power to deal with the same.
Where is this Mr. De? Where is that order passed by the civil court?
Last Chairman.
Page?
Last one, it is page 40, 70, the 69 and 70. Page 16 is the first order, Liberty was given. And this order passed by Climate Civil Junior Division. Page 69. Penultimate page.
No, plaint was returned.
Then, my lord, next page. This order caused some trouble to me, my lord. The last one.
No, initially you filed before which court?
Civil Junior Division, first court.
So there it was returned.
Then filed
To be filed before the proper forum.
proper forum.
Then you filed before the civil judge senior division. Then why you prayed for withdrawal?
They will therefore to file a writ petition with this honorable court according to the petition, but that copy has not been yet sub to me, my lord. What they paid for actually? I've told them to come with the application.
Civil procedure কোডটা দিন তো।
Sorry, my lord.
You have missed this matter.
Yes, my lord. কি আছে বলো?
National Highway Compensation Award দিয়েছে কি ফিট?
%50 if ও ও বুঝতে পেরেছি My lord, in this matter, my lord, if your lordship will say, see page 19.
19?
Yes, my lord.
Now, please give me a minute, I'm coming to that. Yes, page?
Page 19.
Yes, 19.
My lord, the schedule portion. Schedule portion, last part.
Yes.
Acquired area.
Oh, page 19, 19.
Yes, my lord.
19 is the Egra Gram Panchayat, no objection certificate.
না ওটা অন্য কিছু 19
Yes, my 19.
দেখুন দাদা এটা ভুল দেওয়া হয়েছে বোধহয় ফাইলটা
No, file is the correct file, but
19 my lord বলছে তো
This is what you lordship is seeing. It is
আগেরটা 18
it is
that is 18 my lord
18.
18
No, I'm looking at 19. Please see.
then my lord 20 if your lordship will come to it দাঁড়াও না 20 কোথায় না 20 তো না এইটা তবে এতগুলো গ্রাম পঞ্চায়েত এখানে তো এতগুলো দেয়নি
Yes, Mr. Dev, what are you trying to submit?
My lord, that is
20?
24 if your lordship will see.
Yes.
In schedule.
Schedule, yes.
My lord, that is the valuation of structure, not the land.
Yes, valuation structure.
Yes.
Structure and
no, Mr. Dev, his submission is that
yes, my lord, what I want to see, I want to
yes.
say. Structure value is there, my lord. My lord, solar same is given to the land value, not the structure value.
No, he is not saying that.
My lord, now if your lordship will come, my lord, I am coming for that reason.
Yes.
My lord, that is the total. My lord, structure value is 63 lakhs. By 6 lakh
Structure value is
37,000.
36 lakhs.
No, no, একটু দাঁড়াও ভাই। আমার মতো বলতে যাও
3
তাহলে
lakh
তার
64
তোমার মধ্যে আরে ফিগারটা বলবো না। My lord, if your lordship will see the structure value.
Yes.
6,37,880. 888. 888.
Where are you getting that?
That is the page 24 one last serial valuation. My lord, valuation chart. That is the valuation chart.
Yes, but here the structure valuation is 3,67,413.
That is next. that
Oh,
is
sorry,
23.
sorry. Page 23 is also there.
Yes, my lord.
Yes, 6,37,888.
Yes, my lord. 6,37,888.
Huh.
And my lord, Solasium next.
Yes.
That is my lord, total composition 12 lakhs. Now, my lord, that's 50% of 12 lakhs was paid to him. That is rightly paid to him. Where he is not getting the Solasium, he will get only the structure value. Land value, if there is land value, my lord, then he will get the Solasium. How structure value he will get the Solasium?
But that is there, but this determination is something.
No, determination, that is a wrong determination. my lord.
According to you,
That is
the
a wrong
entire payment has been made.
Yes, my lord, that is a wrong determination. That is the value is total composition.
We are not entitled to Solasium from my lord if I got it, my lord. Where is the rules?
Then, my lord, I will give the report in the form of affidavit as because, my lord.
Report.
Yes, my lord.
Because there are two things.
My lord, this is a, my lord, that
I follow your argument, but
I see this, my lord, on the on
but
that
he is
day
also entitled to the land value.
Land value, perhaps land value was given to him. Otherwise, my lord, 0,0. Or
Nothing.
then, my lord, I want to
You
give.
have to say yes. This was the land value. This much
No,
was
this
paid
is
earlier.
this is not the land value, my lord. This
Yes.
is the
Land value
this
is
is the-
0. So land
zero.
value has to be there.
Yes, my lord. That point he is not, my lord, not in the
This is the
calculation
payment
of
notice.
payment notice.
This is not the determination. Where is the award of the?
For that reason, my lord, I must give the
You want
report.
to file a report,
Yes,
report
my
in the
lord.
form of an affidavit.
Yes, my lord.
Yes. That competent authority will file.
Yes, my lord. Competent
Which authority?
That is the ADM.
ADM is
ADM,
the
yes.
respondent number 3.
Yes, my lord.
Let a report in the form of an affidavit.
Just hold on to the time.
You are also not there,
One-
Mr.
156.
I am in the impression of 3 matters before me. All matters are.
Mr. Bandyopadhyay, I am telling you all urgency at the time of mentioning for upgradation. But none were present. This is the only matter which the petitioner appeared. All matters dismissed for default.
Leave to these.
Urgency, you will find at 10:30, urgency is there for upgradation. This much of bundle of slips being handed over. But when it is,
May I hand over the.
so I think now I should stop allowing the pair for upgradation.
May I hand over the.
এটাতে
এটা একটু নেন না
Yes, yes, call the next. Yes. 96. Yes.
That matter.
Which matter? That matter?
Whether it is a mandatory or
Many matters, Mr. Talukdar.
My lord remembers everything by seeing the face. Whether section 3 is mandatory or
This
directed.
is notice,
Notice.
mandatory or
directory.
Directed. My learned senior friend Mr. Bera was appointed as amicus curiae.
Yes, yes, yes.
Several test your lordship, my learned one major, various tests have been given. And your another one judgment.
Better please adjust the micro. Thank you.
Now your lordship can hear that.
Yes, yes.
Several tests have been, my lord, provided by the Supreme Court. Those are to be considered. And we are one of the most important aspect really is what was the intention of the legislature. That will be most important point. That is to be find out.
This is Act 2.
Yes,
Act 2,
my lord.
Act
Yeah,
2.
Act 2. No, my lord, your lordship, before going into that, I want to go to the, but it's say, চারজন আছে আমি তো তিনটে দিতে পারবো না your lord, my lord, before going into the act now, my lord, it's a pre-constitutional act. It was enacted by the then provincial government. What was the original act? I have brought it for your lordship's consideration. এটা কাকে দেবো? সত্যজিৎকে একটা দিচ্ছি আর পিটিশনারকে তপনকে তো দিতে পারছি না। Your lordships kindly see. But purpose I am not disputing. You kindly read for a moment what was the original section 3 at the time of enacting the act. My lord, if in the opinion of the provincial government or any person authorized in this behalf by the provincial government, it is necessary so to do for maintaining supplies and services essential to the life of the community or for providing proper facilities for transport, communication, irrigation or drainage, the provincial government or the person so authorized as the case may be, may by order in writing, here may is used, but may be order in writing, requisition any land. This is one part. And then may make such further orders as appear to it or to him to be necessary or expedient in connection with the requisition. So first of all, an order is to be passed under section 3. Requisition
in writing.
In writing. And requisition means seizure of the property, your lordships can say. The government seized the property, it is under requisition.
To take possession.
Then that will be most important. Then, my lord, second part would be important, may make such further orders. So, first order of requisition, and then, my lord, further orders have to be passed. Unless possession is taken, it cannot be executed. That will be the important part. That's why 2 parts. Then, my lord, provided a proviso, I am not reading.
Yes, proviso may not be relevant.
Now, my lord, kindly see, an order under subsection 1 shall be served in the prescribed manner on the owner of the land where the orders relates to land in occupation of a tenant, also on such tenant. This was this. On the owner or tenant. Occupier.
So it says person in occupation also has to be notified.
Notified. Has to be notified. 2 parts. Your lordship knows better than me. Possession may be of owner and possession may be of tenant.
Possession.
Maybe legal possession.
Yes.
Legal possession must be legal.
Yes.
Maybe a tenant, maybe a lessee, or otherwise, if a possession is in adverse possession more than 12 years, he got his title on the property. So, my lord, in that context, it will be read the person who is in possession, he shall be served with the, it may be owner or it may be occupier. And maybe owner may be in possession of the. Then, my lord, here I am. Then kindly, I am not going to section 4. This has 2 parts. Kindly now come to section 6. Where any land requisition under section 3 is not acquired and is to be released from requisition, the provincial government may, after making such inquiry, if any, as it considers necessary, specify by order in writing the person who appears to be entitled to the possession of the such land. Then, my lord, the delivery of possession of such land to the person specified in the order made under subsection 1 shall be full discharge of any liability of the provincial government to deliver possession to such person as may have a rightful claim to possession thereof, but shall not prejudice any right in respect of such land which any other person may be entitled by due process of law to enforce against the person to whom possession of the land is so delivered. Where, etc., I am not going to treat for. So, it has two parts. So far, this law is concerned as originally enacted. If it is only required for temporary purposes, you requisition the land, use the land, and if you want to release the land, pass an order under section C, release the land. This much of the requisition. Two things can be done by this act. Temporary requisition means temporary. Requisition
cannot be for a permanent purpose.
Cannot be for a permanent purpose. So after completion of requisition period, you restore back possession to the rightful owner from whom you have taken possession. This is one. Then section 4 will come into play only
to acquire.
So vesting, etc., nothing to do.
So Chakraborty, you can take your seat.
You take your seat.
Yes.
So, my lord, this. Now, my lord, kindly take the rules framed simultaneously with the Act 1948, pre-constitutional, all pre-constitutional. You know, Satyajit.
Yes.
Remember, kindly come. Rule specifies section rule 3.
Rule 3.
Yes.
Yes. Manner of service.
Manner of service. An order under subsection 1 of section 3 shall be served on the owner of the land, and where the order relates to the land in occupation of an occupier, not being the owner of the land, and also on such occupier. So, my lord, subsection 3(2), here it is rewritten. It must be served in the following manner. By four methods are by delivering, etc. I am
not on that.
I am not on that. So, rules also confirm that the order is to be served upon the owner or upon the occupier in the manner specified therein. Then, my lord, your lordships kindly come to 4. 4 says the orders under subsection 1 of section 3 and subsection 1 of section 6 shall respectively be as nearly as possible in form number 1 and 5 appended to these rules. Now this
form has been specified.
But here part of the requisition order has been made in the form 1. Then it says, and make the following further orders, namely here it is gap.
No, where?
Kindly come to page 37, next page. Order form number 1.
Yes, form number 1.
Yes, kindly come to bottom.
Yes.
May here is requisition the lands mentioned in the schedule below,
yes,
and make following further orders, namely. This is important, but this is in consonance with the act. Further orders.
Yes.
That means they are to inform the owner or occupier of the property on such and such day possession of the land will be taken or you hand over the possession.
Yes. So, according to you,
yes,
the first part is it will be said that this property is being requisitioned.
Yes.
Now, when the possession is to be delivered, how, to whom,
yes,
that is the further order.
Further order. So, it is a combined order under section 3(1), 2 parts. First, order of requisition, then how the requisition property will taken possession of. So, and rule says it is to be served. Prima facie, even on the date of enactment of the act, it was the intention of the government that the order is to be served upon the persons. Prima facie, I am telling you, prima facie it means everything it is followed by rules.
Yes, service is contemplated under the act as well as under the rules.
As the rules.
Now the only point is,
yes,
here the expression shall is used in the rules.
Yes.
And in the act also.
Yes.
Me by order also uses the expression shall.
Yes.
Now the question is how this shall is to be interpreted.
Interpreted as
Whether it's mandatory,
mandatory or
or
not.
direct.
Then, mirror, subsequent theory the Supreme Court has followed, what will be the consequence of non-service. Now, mirror, here, as I understand, mirror, if no notice is served, consequence cannot be prescribed. Cannot be prescribed. What will happen? It will make the requisition order bad or it become invalid. So no consequence in the act can be provided. That is to be, my lord, ascertained from the intention of the legislature. That's my say. My lord, if the notice says possession is to be taken, what is the possessory right? Possession is a special kind of interest in the land, apart from ownership of the land. And if a person, without serving notice under section 3(1), possession is taken, what it amounts? It is amounts to, my lord, the forceful possession. Can a statute be framed by the government that this possession will be taken from the landowners without serving notice upon him? Can legislature legislate such a statute? That is statute, if it is directory, not mandatory, then it authorizes the government to take possession of the land without due process of law. It amounts to forceful possession, or rather trespass. Can a statute be framed in such a manner that if it is a directory, then, my lord, trespass is shall be it shall be, my lord, inferred that the legislature intention is to trespass in the land without serving notice upon the land. My lord, that's my understanding. There cannot be such a law. Then, my lord, at that time, it was not a constitutional right. Now, my lord, your lordships kindly come. After constitution, what was the right to property? 19(1)(f) fundamental right, and 31 of the constitution. Have a look into this. 19(1)(f) I am not pressing. Kindly have a look. How property is to be acquired or requisition. Kindly have a look to old constitution I have brought, pre-constitution, pre-44th amendment, 31.
Yes.
First clause, I have not got the first clause, no person shall be deprived of his property save by authority of law, which is, only part of this 31, which has been rewritten in 300A. Other parts have not been. Now, my lord, subsection article 2, rule 2, subrule 2, rule 2 speaks what is acquisition and requisition. If acquisition and requisition law is to be passed, then it must provide for compensation.
Yes.
And 2A is not compensation, but where other law can be passed by the state, where ownership of the property will not transfer to the government, then it may provide for minimum compensation, but that is not the acquisition. That is the distinction between this. So this was the right. After coming into this law continued to be law, my lord, under 376 of the Constitution. So, my lord, now immediately after this act come into operation, these constitution came into office. So it speaks, it was a fundamental right, and he cannot be deprived of his authority, he deprived of the property without authority of law. This continued up to, my lord, 1979, when, my lord, this
300 capital A.
Yes, 300 capital A, 44th amendment.
Yes.
Well, 44th amendment came into effect on 20th June 1979. New constitution, Lord, I am handing over to you, Lord. So, after 44th amendment, this becomes constitutional right. That is there. So, my lord,
only the first part, subsection.
Yes, first part is 300A.
Only has been incorporated.
It also says, no person shall be deprived of his property save by authority of law. Taking of possession without notice means, my lord, taking of possession of the property without due process of law. It will be up to, my lord, 79. It will be violative of 19(1)(f) and 31. And, my lord, after 44th amendment, 300A, it will amount to deprivation of the property. My lord, this, so statute cannot be held to be, 3(2) cannot be held to be direct. No person can be deprived of his property without authority of law. Now, in this context, some judgments, my learned friend has relied upon some judgment. This is the gist of my submission. Kindly, in addition, I am filing one copy of the judgment, 76 Supreme Court. In addition to that, I will come to my learned friend's decision. AIR 1976 Supreme Court 263. Kindly come to, but this is a case where, my lord, the provision of Gujarat Agricultural Produce Market Rules 1965, which provides that, kindly come to read for a moment 6.1.
Which paragraph you are placing?
Para 6.
Para 6. Yes, yes.
Declaration of market areas. After the,
yes,
sorry, but kindly come to 6. Yes, after the expiry of the period specified in the notification issued under Section 5, herein after referred to in this section as the said notification, and after considering the objections and suggestions received before its expiry and holding such inquiry as may be necessary, the director may by notification in the official gazette declare the area specified in the notification or any portion thereof to be the market area for the purpose of this act in respect of all or any of the kinds of agricultural produce as produce specified in the notification. A notification under this section shall also be published in the Gujarati in the newspaper having circulation in the area and in such other manner as may be prescribed. The question come up for the later part, whether the notification under by
is mandatory.
Is mandatory or not. It has been held, it's mandatory. Also because of the language used also. Then, some questions of law, kindly come to para 8. The simple question, though important, whether the notification issued under Section 6.5 of the Act, covering additional varieties of agricultural produce like ginger, etc., onion, must not be published in the official gazette, but must also be published in the Gujarati newspaper. Then, your lordships kindly come to para 10 straight away.
Yes.
But here, the theory has been explained. But the little complexity that there is in this matter arises out of a known phenomenon, judicially noticed but otherwise disputed, that sometimes the legislator does not say what it means. That has given rise to series of technical rules of interpretation devised or designed to unravel the mind of the lawmakers. If the words used in a statute are ambiguous, it is said, consider the object of the statute, have regard to the purpose for which the particular provision is put to the statute book, and then decide what interpretation best carries out that object and purpose. The words of the concluding portion of Section 6.1 are plain and unambiguous, rendering superfluous the aid of artificial guidelines to interpretation. But the matter does not rest there. The appellant, respondent, has made an alternative argument that the requirement regarding the publication in Gujarati newspaper is directory, not mandatory.
Yes.
Then, despite the use of the word shall, that word, according to the appellant, really means may.
Yes.
Then, some statutory some important authorities has been said. The Maxwell, Crawford, and Craig abound in illustration where the words shall and may as treated as interchangeable. Shall be liable to pay interest does not mean must be made liable to pay interest. And may not drive on the wrong side of the road must mean shall not drive on the wrong side of the road. But the problem which the use of the language of command poses is, does the legislature intend that its command shall at all events be performed, or is it enough to comply with the command in substance? In other words, the question is the provision mandatory or directed? Plainly, shall must normally be construed to mean shall and not may, for distinction between two fundamental. Granting the application of mind, there is little or no chance that one who intends to leave a leeway which will use the language of command in performance of an act. But since even lesser directions are occasionally clothed in words, of authority, it becomes necessary to delve deeper and ascertain the true meaning lying behind the words. Crawford on statutory construction sets out the following passage from the American case approvingly. The question as to whether a statute is mandatory or directory depends upon the intents of the legislature, not upon the language in which the intent is closed. So this is, my lord, point number one. I am telling intention of the legislature.
Yes.
The meaning and intention of the legislature must govern, and these are to be ascertained not only from the phraseology of the provision, but also by considering its nature, design, and the consequence which would follow from construing it one way or the other. This is the second point. But suppose if no notice is served, what was the consequence? I have told your lordship to take possession of the laws and to enter into the land as a trespasser. That cannot be the statutory form of legislation. Legislation cannot make such a law authorizing government to enter into the land without serving any notice or without serving the copy of the order. That will be the consequence. That is second. Thus, the governing factor is the meaning and the intent of the legislature, which should be gathered not merely from the words used by the legislature, but from a variety of other circumstances and consideration. In other words, the use of the word shall or may is not conclusive on the question whether a particular requirement of law is mandatory or directory. But the circumstances that the legislature has used a language of compulsive force is always of great relevance, and in the absence of anything contrary in the context indicating that permissive interpretation is permissible, the statute ought to be construed as peremptory. One of the fundamental rules of interpretation is that the words of a statute are themselves precise and unambiguous, and no more is necessary than to expound those words in their nature and ordinary sense, the words themselves in such cases best declaring the intention of the legislature. The next is the footnote. Kindly the reference is the footnote. Then, my lord, leaving it, section 6(1) of the Act provides in terms plain and precise that a notification issued under section shall also be published in the Gujarati newspaper. The word also provides an important clue to the intention of the legislature, because having provided that the notification shall be published in the official gazette, section 6(1) goes on to say that the notification shall also be published in the Gujarati newspaper. The additional mode of publication prescribed by law must, in the absence of anything to the contrary, appearing from the context of the provision or its subject, be assumed to have a meaning and a purpose. In Khubchand versus State of Rajasthan, it was observed that the term shall in its ordinary significance is mandatory, and the court shall ordinarily give that interpretation to that term unless such an interpretation leads to some absurd or inconvenient consequences. Madam, this will be important. This is one of the part also. Be at variance with the intent of the legislature to be collected from the other parts of the Act.
The Act is to be read as a whole.
Always. Because in an act, mirror, there may be several provisions which are mandatory with the word shall, with the word may, that may not be maybe directory. In a statute, it is not necessary that all the sections shall be mandatory, where shall be used. So it is to be intention what is necessary. Suppose if an interpretation is given where general public is affected, so that situation is also to be considered. Here, question of consequence of suffering of the general person doesn't arise. It restricted to the person who will be affected. Who will be
particular person?
That particular person. That owner of the person, that owner or the occupier. Non-service means taking away the property without authority. But the statute can provide that. That's why, I am saying. The Act set expression. Yes. The next para, several tests have been propounded in the same principle was expressed thus in Haridwar Singh versus Begum Sumbari. Several tests have been propounded in decided case for determining the question whether a provision in a statute or a rule is mandatory or directory. No universal rule can be laid down on this matter. In each case, one must look into the subject matter and consider the importance of the provision disregarded and relation to the provision of the general object intended to be secured. Recently, in presidential election, the learned Chief Justice, speaking on behalf of the 7 judges bench, said, observed, in determining the question whether a provision is mandatory or directory, the subject matter, the importance of the provision, the relation of that provision to the general object intended to be secured by the Act will decide whether provision is directory and mandatory. It is the duty of the courts to get at the real intention of the legislature by carefully attending to the whole scope of the provision to be construed. The key to the opening of every law is reason and spirit of the law. It is the animus importance is the intention of the lawmaker expressed in the law itself taken as a whole. So, my lord, scope of 48 Act is very limited. For the purposes mentioned in the Act, you take away the property from the individual owners and use it for the purpose for the public purposes for which it was taken. Can that be done without serving notice to the landowners? I am just imposing this question. What is the real intention of the legislature? And that is also followed by rules. That also says that it is to be served. So, my lord, a person's who ultimately it is to be held by your lordships that the purpose of Act 2, either to requisition, but the takeaway of the property by the government, or if it's want to acquire the property, that means ownership is transferred to the landowners. If the ownership is want to be taken away by the government, then that mode is to be followed by publication of a notice. In both cases, the persons are affected. The property, owners of the property or occupiers of the property are affected in both cases. In case of requisition, also in case of acquisition. So, keeping him in dark, saying that these provisions are directory, Lord, it cannot be done. It cannot be the object of the statute. 8 or 9 sections are there, then 5A is serving notice like section 9 of the Land Acquisition Act. Then section 7 speaks for award, it's a composite manner. Then section 8 speaks of the reference to court. And then 8B is giving them 80% of the compensation affected if the government wants to acquire the property permanently. So what it means, keeping him in dark, I am going to take away your property, 80%. Suppose the government wants to acquire the property. So keeping him in dark, 80% compensation will be paid or not paid. Can it be said? So the whole intention, very small, whole intention of the legislature, you do the procedure prescribed in the Act step by step. Not keeping the owner occupier of the property in dark.
Yes.
I am assisting your lordship. Don't, Mr. Talukdar.
Certainly not. we are learning.
What I understand, Mirror, next one judgment, Mirror, one paragraph will be intended. So, Mirror, from that judgment which I have submitted, Mirror, the gist is intention of the legislature, considering its nature, its design, and the consequences which would follow, the shall mandatory importance of provision disregarded and relation of the provision to the general objects intended to be secured to get at the real intention of the legislature. These are the gist of that. Then, Mirror, another one judgment which has been relied upon in so May George's case, Mirror, I have brought that judgment that will be also relevant. That is, Mirror, 76-2, Supreme Court cases 895.
76
to 895.
So you did not give that because Mr. Talukdar has given.
No, it is not. He has given major. It has been referred to there. I am relying on the full judgment.
76-2.
76-2 SCC 895. আমি দিলাম তোমাদেরকে একটা দর্শকের কোটা দিলাম স্যার ও আচ্ছা আমার কাছে only one.
This was considered in major.
Yes,
that he has said.
I said paragraph. It has been relied in para 18 of majors. I will come to majors last. After all, Mr. Talukdar has relied upon majors. I have to explain the major. To assist your lordship, I have to explain major. Now it has been relied in para, Mirror, 10. Yes, para 10. Here is a summary. In determining the question whether a provision is mandatory or directory, one must look into the subject matter and consider the importance of the provision disregarded and the relation of that provision to the general objective intended to be secured. No doubt all laws are mandatory in the sense they impose the duty to obey on those who come within the purview, but it does not follow that every departure from it shall tend the proceeding with fatal blemish. The determination of the question whether a provision is mandatory or directory would, in ultimate analysis depend upon the intent of the lawmaker. And that has to be gathered not only from the phraseology of the provision, but also by considering its nature, its design, and the consequences which should follow from construing it in one way or the other. We see no reason why rules should receive a permissible interpretation instead of peremptory construction. As we said, the rule was enacted for the purpose of enabling Deputy Commissioner, Land Acquisition Collector to have all relevant materials before him for coming to his conclusion to be incorporated in the report to be sent to the government in order to enable the government to make the proper decision. In Lonapan versus Sub-Collector Palghat, the Kerala High Court took the view that the requirements of the rule regarding giving notice to the department concerned was mandatory. This view of Madras High Court in such and such verses is also mandatory. In this case, what happened, my lord? Section 5A of the Land Acquisition Act provides that after publication of notification, the owner shall file an objection to the acquisition of the land within 30 days from that, and he shall be given an opportunity to pass an order, etc. Host of decision on 5A2, violation of 5A2 makes the acquisition proceeding bad and illegal. They are a very judgment. Here in this case, in addition to that rule, to give benefit or to give advantage to the requiring body, whether to give advantage to the requiring body, provisions were made that in addition to 5A, copy of the objections and also to be sent to the requiring body. Now it was argued on behalf of the opposite party that since not mandatory, since 5A is there, everybody. Supreme Court says no. Requiring body has so much to say against the objection filed by the landowner. So they should be given also a chance. So that's why it has been said that the rule is mandatory. It is with regard to land acquisition rules framed.
Yes.
Before going into major, another same, your lordship much aware of this, specifically so far as the rain control legislations are concerned. Herein, this is to be deposited within such day unless the strike, etc. Those are not held to be mandatory. But still then in connection with the rain control legislation in our rain control legislation in state of West Bengal, 2024 to SCC 169.
Devashish Pal.
Yes, Devashish Pal. Your lordship remember that. Only one paragraph I will be relying. That is paragraph before going into major.
Have you brought the decision of 2003, Nasiruddin?
I have not brought that so much.
Because Nasiruddin has been relied in Devashish.
Yes. Nasiruddin has been relied. Kindly
Nasiruddin,
come to para 15. I have not brought the decision. It has been referred to here. It will be
56
only paragraph 15, Nasiruddin, your lordship knows.
Paragraph 15, Nasiruddin has been quoted.
Yes, quoted.
Yes.
It is well settled that the real intention of the legislature must be gathered from the language used. It may be true that the use of the expression shall or may is not decisive for arriving at a finding as to whether the statute is directory or mandatory, but the intention of the legislature must be found out from the scheme of the act. It is also equally well settled that when negative words are used, the courts will presume that the intention of the legislature or the provisions are mandatory in character. That is settled position of law.
Next paragraph is important.
Yes. If an act is required to be performed by a private person within the specified time, the same would be ordinarily be mandatory. But when a public functionary is required to perform public function within the time frame, the same will be held to be directory unless the consequence thereof specified one. Yes.
So here it is public function.
Yes. Here public function.
It makes a distinction between if the private person is required to do something and a public authority is
here public. There is no private person. Here public authority is to be.
So here 38 would be relevant.
Yes.
Paragraph 38 of Nasiruddin would come into play here.
But a public function, whether section 32 speaks of public function or other public function, I will go to that. statutes, other statutes are there. Whether service of notice is a public function, is public at large is affected by non-service? Not. Here, in serving the notice, no public function is being carried out by the authority. It is to be issued by the appropriate authority, then it is to be served. It is not a kind of public purpose. The public, it is not a public duty. Public duty means some other things. A governmental authority is required
But the purpose is a public purpose for which it is sought to be required. Requisition.
Yes.
That's the this
It is
entire
public
exercise
purpose. Requisition
by a public functionary for
Yes.
public purpose.
Yes. Public purpose. Then mirror, what will lead to it? My
Then
question.
it says unless the consequences that
Yes.
those cases
Consequence, if
are
it
to
is
be
not
provided.
followed, consequence, if it is not provided in the statute, then your lordships have to find it out from the statute.
Yes.
So, Miller, what I say initially, that purpose of section 3(2), service of order of requisition and also to take possession of the land. Is it a public duty? It's one sense your lordships can say public duty, but publics are not affected by this general. It is the only person.
In a way, if this is held that acquisition or requisition is bad, then the public will be affected. If
Yes.
consequences is the public will be affected.
Yes, yes. No,
Public will be affected. So it's a public function because requisition
yes,
is a public function which they are trying to do.
yes,
Now, if non-service for that the entire process is held to be bad,
yes.
then the public at large will be
Public
affected.
will be at large will be affected because the purpose of acquisition is this. No matter then problem will be how to solve this problem. Can a property be taken away from the landowner without serving notice? That is the moot question. That is the moot question. Can a property be taken away? I know consequence of land will be used for the public purpose, but consequence will be that the public will be at large will be affected. But another consequence will be that the landowner will be deprived of his right of deprived of his property, which will be violative of 300. Now, Miller, your lordship's consistent view of Supreme Court is this: that deprivation of property or 300A, violation of 300, it amounts to Miller the violation of human rights. It's violation of human rights. So can that be supported? Now, my lord, kindly come to that unless consequence public function. I think, my lord, this has been also explained in some cases. My lord, kindly come to me, lord. Now, May George. Now, your lordships kindly come to May George.
What is the citation?
Well, citation is May George, 2010-13 SCC, page 98. Paragraph 14 to 25, I think.
2010?
2010, volume 13, SCC 98. It is in the bunch given by, that's why it is in the bunch given by Mr. Talvida.
Not 10-13, yes.
Yes, yes.
No, no, he has given a
yes,
given a copy of it.
Loose copy.
Yes.
Not a compilation.
No, my lord,
Not a compilation.
not a post, sorry. It has been served upon me as a compilation, that's why I have thought what it has been. No, my lord, May George was considered in the context of Section 9(3) of the Land Acquisition Act. Before going into these decisions, your lordships kindly have a look to Land Acquisition Act.
Land Acquisition Act তো আছে এখানে।
amendment made in section 3.
Yes.
Kindly come to section 3.
Yes.
1A is not relevant. Has your lordship got it? Then, my lord, an order under subsection that is there. Then 3. It was added in 1954 Amendment Act. 3.
Yes,
If a
54
person,
Amendment Act, yes.
yes, if a person fails to comply with the order made under subsection 1, the collector or any person authorized by him in writing in this behalf shall execute the order in such manner as he consider expedient and may, if he is a magistrate, enforce the delivery of the possession of the land in respect of which the order has been made to him, and if he is not a magistrate, apply to the magistrate or in Calcutta as defined in section 11, subsection in clause 11 of section 5 of the Calcutta Municipal Corporation to the Commissioner of Police, and such magistrate commissioner, as the case may be, shall enforce the delivery of possession of such land. But this you have to consider by your lordship. If
this is execution, Mr. Bera, this is execution of an order.
Execution of order.
Execution of an order is not a consequence of non-service.
I am saying this become redundant for non-service. Kindly see it in the other way. If no order is served, then this provision of section 3 becomes redundant. You must serve, then you must execute. Then what is the purpose of bringing this amendment? It is execution certainly, but how the order can be executed?
So according to you, it becomes a non-executable order. It becomes a non-executable order then.
Yes, non-executable order then. What is the purpose of bringing this amendment? What I am saying, without service, can this
will be only a paper order?
Only a paper order remain in the file. You need not. Suppose without going there to forcible possession, as is usually done in this. Not in this in our state. I am saying many cases are there. Himachal Pradesh, etc. So many cases went to Supreme Court. Non-service, taking away the property, construction of road, by the side lands are taken, no notice, no acquisition, etc. What I am interpreting in this way, the purpose of this to execute the order. Unless order is served, you can't execute. So order, service of order become mandatory to become effective this subsection 3. Otherwise, subsection 3 becomes, which is brought by way of amendment 1954, will be redundant. There is no necessity at all. Then if it is a directory, there is no necessity of at all. Order will be there, government will go to the land, not service will be there, and government will proceed with the land in their own way without serving any order. That will be the consequence. Enforcement comes in if the order is served. If the order is not served, enforcement of the order does not come into play.
Execution will be a problem then.
Yes. So that's why resistance, government's authorities had to face resistance by the landowners. If there are a chunk of landowners are there, several examples are there, your lordship, I need not repeat those cases, those aspects your lordship knows. For this cannot be acquired, this cannot be acquired, these are there. So yes, the government may face such after service, and if it is not served, then what is the consequence? It remains as a paperwork. And government will proceed without serving, say it is directory. Only they will pay compensation under section, I think under section 7.3 provides for requisition compensation. 7.3 speaks of requisition compensation.
Yes.
And section 7 starts for the compensation of acquisition. So this is most important. Why this amendment was brought in 1954. Other amendment I am not tracing. I am not looking. This will
7.3 is requisition compensation.
Yes, 7.3 is requisition compensation.
Yes. Now you wanted to see the Land Acquisition Act.
Yes, Land Acquisition Act.
Yes.
So kindly see, I will not 2 or 3 sections. Kindly see section 4. Wherever it appears to the appropriate government that the land in the locality is likely to needed for any public purpose or for a company, a notification to that effect shall be published in the official gazette, and 2 daily newspapers circulating in the locality, of which at least one shall be in the regional language, and the collector shall cause public notice of substance of such notification to be given at convenient places in the said locality, and the date of such publication at the giving of such public notice being referred to as the date of publication, if the notification shall may nothing used. Each of the clauses, each of the steps are mandatory, consistently held by several decisions of the Supreme Court. You cannot skip one. First or second, whatever may be, there may be stages. You may first publish in the local newspaper, 2 daily news, local news, 1 in the regional language. Then you must publish in the gazette. Then you must give a public notification of the public notice of the acquisition. No, here, shall is not used, may is not used. If the government wants to acquire the land, you are to initiate the acquisition proceeding by.
No, shall is used, shall be published.
Yes, shall is used,
Shall be
shall be published. But if it is said, what is the purpose of this notice? To inform all the lands, particularly the landowners, that these are the plots, it will be acquired. Then gazette. থ্রি তো আমি যাচ্ছি না তো, থ্রি কিসের থ্রি? থ্রিতে গিয়ে কি হবে? কোন থ্রি? সেকশন 3? সেটা পরে পড়ছি আসছে। মানে all these provisions have been held to be mandatory. Then, hearing of objections, I am not seeking. Kindly come to section 6. Subject to the provisions of part 7 of this act, the appropriate government is satisfied after considering the report, if any, made under subsection 5A, subsection 2, that any particular and is needed for public purpose or for a company, a declaration shall be made to that effect under the signature of the secretary to such government or some officer duly authorized to certify this order. Different declaration may be made from time to time, parcel of land covered by the same notification under section irrespective of said, provided that by notification under section 6, mirror first II, provided published after the commencement of Land Acquisition Act 1984 shall be made after the expiry of 1 year from the date of publication of the notification. Now, if we said 2, the section 4 speaks once gazette, newspaper, 2 newspapers, 1 in the local newspaper, then publication, public notice of the substance of the acquisition proceeding in their locality. No steps can be mirrored. No steps can be provided, can be skipped. Sorry, no steps can be skipped. This has been held to be mandatory. So if we say that why it is necessary, one of the publication may be skipped, what will problem? What will be the problem? Gazette is sufficient indication that the property will be
public notice.
And then last public notice in their locality. What are the purposes? These are for better information to the public that these properties are to be acquired. So all these steps are mandatory. Then this 1 year. This year has been held to be mandatory. No, your lordships will kindly note that.
Year is
mandatory. But here steps is that it is other consequence is not there. If not within 1 year, consequence is not there. So, because why? After all these provisions of the act are I must say, for benefit of the landowners.
Protection of the right to property.
Right to property, and all these provisions are beneficial piece of legislation. And no such provisions are there. It has been said those are beneficial provisions of section 4A. But if we go to section 3, we cannot say it's a beneficial piece of legislation. But if it is violated, it will affect the landowners. To that extent, it is this subsection 2 of section 3 is a beneficial landowner for the landowners or the occupiers. That is to be kept in mind also. Now, my lord, kindly come to, in this context, 11A, mandatory.
Yes, 11A is mandatory.
Mandatory. Then kindly, in that context, kindly come to section 9.
Yes.
So 9(3) state, the collector shall also serve a notice to the same effect on the occupier, if any, of such land, on all such persons known or believed to be interested therein, or to be entitled to act for persons so interested, as reside or have agents authorized to receive notice on their behalf within the revenue district in which the land is situated. This is mirrored when acquisition proceeding. It is a pre-notice before publication of award. This is notice 3 to serve upon the interested person to ask them to submit their claim before the government. That is the true import of section 9. That your property sought to be acquired by such acquisition proceeding. If you have any interested, please state your nature of interest. Please state what is your claim regarding the claim for compensation. This is the purpose of serving this notice. This has been held to be directed. Why? Mirror, because it does not affect the quantum of compensation. If no notice is served, collector will declare the award under section 11. The landowner will be served with a notice under section 12(2). Nowadays, government, of course, I do not want to make any comment. Then 12(2) notice will be served, and after getting 12(2) notice, they will ask for reference to court seeking higher valuation. This is really to regarding the claim for compensation and the nature of interest. If other persons whose names are not appearing in the notices, if they have any interest in the land, they can also make such claim. So, it's really intention of this subsection is to intimate the landowners regarding the nature of their claim, in the nature of their interest in the land, and specifically they can also say what is the compensation they are claiming for the acquisition of their land. What has not been, it has been held to be directory, I also accept that, but it has not been mentioned there. One important aspect your lordships will kindly see, before 1984 amendment, what was this 9(3) has a nexus with section 25 of the original act before 1984. Your lordships kindly see, that is not explained there.
Because object of section 9,
yes,
is to inform the persons that possession will be taken.
No.
This is 9(1).
No. Possession.
This is 9(1).
Yes. Just a minute. Just 9(1). Yes.
Yes. Intention to take possession.
Yeah. The collector shall then cause public notice to be given at convenient places or near the land to be taken, stating that the government intends to take possession. Intends to take
So
possession.
the object of section 9,
yes,
is
and claims for compensation.
Intention of the government to take possession.
Take possession.
Similar is the intention under section 3.
Yeah.
That requisition further order to take possession.
Yes.
So 9(3) is
yeah.
Notice of the intimation that the government is intending to take possession.
That is 9(1).
9(1)(3) also follows, because that is for that.
Yes.
The persons interested are to be served. One
Yes.
is public notice, another is individual notice.
Yes. It is public notice.
Another is the individual
Another
notice.
is the individual notice under section 3.
Yes. So
yes.
this individual notice is also
yes.
for the purpose that the government is intending to take possession.
Yes, that's right. But by intending to, but
similar is the effect of 3.
No.
Requisition
No.
further order is intending that possession.
No, not intention. Your lordship, if I am not wrong, my lord, your lordship's possession under the Land Acquisition Act cannot be taken under section 9. It can be taken only under section 17 or under section 16.
Yes, yes. After the declaration of the award.
Yes,
that is
only after that.
After
So
that vesting
but
possession.
here Here,
But intention to take possession.
intention to take possession and that to take actual possession, those are two different
No, no,
aspects.
these are two different. To
For
take
section
actual,
3.2 is not intention to take possession.
it's actual taking over of possession.
Yes, your lordships kindly actual taking over. My kindly take for the simple model. Your lordships kindly take Taraknath Sen's case. Kindly come. My London friend, the writ petitioner has filed. Kindly come. Your page. Yes. Paragraph 1.
What is the citation?
That is Taraknath Sen versus First Land Acquisition Collector. The model. I am referring to the model. First paragraph of Taraknath Sen versus First Land. I am not going to other parts of the judgment. Only to show what is the real form. First part is there in the model. Second part is not there.
Taraknath Sen, do you have an extra copy of that?
The marking is not very well. First paragraph. We will kindly skip 1, 2, 3. Now 4. Now
which paragraph?
First paragraph.
First paragraph.
Where the model notice has been quoted.
Yes, yes. Form of the order, yes.
Form of the order. Kindly come 1, 2, 3, skip 4th. Now, therefore, in exercise of the power conferred by subsection 1 of section 3 of the West Bengal Land Requisition Act, read with authority so vested in me, I do hereby requisition the land mentioned in the schedule below. That is there in the section 3. Then make the following further orders. That the land described in the schedule below will be placed at my disposal and control on Act when the other officer deputed from this office will take charge and possession of the land. Not intention. Taking of actual physical possession, that is the further order. Unless that is done, government cannot get control of the property. Landowner is to be his possession is to be taken to take control of the property. And section 9 speaks of intention. This is the order served. If this is not served, that's why from all angle, then kindly come to 25. I'm just this is the notice to the person interested. General information. This is given 9.3. This is followed. This is to be seen. But just I am very old book. Section 25. Then we kindly read that. But only by 1984 amendment, sub-rule 1 and 3 has been omitted. 2 is there, but kindly read subsection 1. A rule as to compensation. This is to be read along with section 9.3.
Yes.
After amendment 2 is only there. The court's award will not be less than collector's award. That is restricted to only that is 25 other there. So 9.3 has a nexus with this. If any person do not make any compensation, he is at liberty to make compensation in the reference court. But if he submits a claim that this is my claim of property, court cannot go beyond that.
All right. Please
That's
give a
why
photocopy of this. Photocopy of these rules.
Yes. So this has a nexus. There has never been mentioned in this Major's case.
You can give it subsequent, not,
Yes.
yes.
So, mirror, that's why I am saying in Major's case, now kindly come to Major's case, why it has been held to be directed. But I am saying there is nothing wrong in it because it's directed in nature because he has several other remedies against this section 9C notice. Suppose after this he did not make any claim, collector will declare an award under section 11, serve notice of
If he is aggrieved, he can
move section 18, etc. Whatever may be his right. So that's why it has been held to be directed. Now, my lord, I am not going to that aspect. Now, kindly come to the rule. Better mirror. Kindly come to that has been paragraph 14. That has been said. It has been held to be. Now, kindly come to para 16 onwards
of Major's.
Major's, where mirror the interpretation has been given by the Supreme Court that these are the tests of directory on mandatory. In Miller Dattato Moreshwar versus State of Bombay, this court observed that law which creates public duties is directory, but if it confers private rights, it is mandatory. Relevant passage from the as quoted below. It is well settled that generally speaking, the provisions of statute creating public duties are directory, and those conferring private rights are imperative. When the provisions of a statute relate to the performance of a public duty, and the case is of such that to hold null and void acts done in neglect of his duty would work serious general inconveniences or injustice to the person who have no control over those entrusted with the duty, and at the same time would not promote the main object of the legislature. It has been practice of the court to hold that such provisions are directory only and neglect them of not affecting the validity of the acts done. Number one, it refers to public duty. Question is this, whether service of notice is a public duty or is a consequence of execution of the order passed under subsection 3. It's not a public duty. There is a distinction between public duty and a statutory duty. Certainly, public duty emanates from the statute. It may be, but it's a specific statutory duty required to be complied with. Otherwise, the consequence of non-service, what will happen to the landowner? Your lordships, it can be seen from the two angles. As your lordships is saying that if for non-service an order of requisition is held to be bad, acquisition is held to be bad, etc., then the general public
here is that inconvenience or injustice to persons who have no control over this.
Yes. The persons who will be affected, the persons who are benefited for the acquisition.
Yes.
For the benefit, that is the public. Public purposes will be affected. But whether non-service will that, remedy is there. Remedy is under the law is there. If a property is taken, government cannot claim that I have taken adverse position. No, my lord, that Supreme Court judgment is there, my lord. Just name I cannot say, my lord. Remember just now. Government cannot claim adverse position. So what it amounts? Take the notice I have shown to your lordship that to take and control possession of the property on such day without serving notice. Consequence. Acquisition, your lordship has times and number held that the acquisition is held to be bad and the property has been used, then follow the due process of law. What is provided in 300A or initially what was in 31(1). Due process will pay just and proper compensation what is available to them under the law. Under the law, requisition. Your lordships can hold requisition is bad in law because then question arises when the compensation and how the compensation is determined. Then the wrongdoer will face it. So, the public duties, to my understanding, it is not a public duty to serve notice upon the landowner. It is a consequence of or execution of order under section 3(1). It's not a public duty, it's a statutory duty provided in the statute. Then, next question, so, here, public duties are directed. No problem, Mirror. Public duties, there may be several examples, Mirror. I cannot just now, Mirror, side was public duties in various statutes. Public duties are there, Mirror. So many laws I have evolved on this. Public duties or Mirror other public law element in the statute, etc., etc. The public law violation of public law element is there, etc. That is, I am not going to that extent.
Yes.
Then Mirror Constitution points instead of UP versus Baburam, that is Mirror page 65. That is page
70.
Para 70. For ascertaining the real intention of the legislature, the court may consider inter alia the nature and design of the statute and the consequence which would follow from construing it in one way or the other, the impact of other provisions, whereby the necessity of complying with the provisions in question is avoided, the circumstances, namely, that the statute provides for contingency of non-compliance with the provisions, the fact that the non-compliance with the provision is or is not visited by some penalty, the serious or trivial consequences that follow from therefrom, and above all, whether the object of the legislation will be defeated or further. So here we are not coming within this, Lord. I think, Lord, this is we are not coming within this. The consequences follow only. Statute did not provide non-service. On the contrary, after amendment, statute provides after serving of the order. If the owners refuse to or occupier refuse to comply with the order, then how it is to be executed? It is the consequence provided there. Not non-service, what will happen to non-service, that is not provided there. But if the order is served and if it cannot be executed, then provisions have been made for execution of the order. That is there in 54 amendment. Then, my lord, in Raja Bulanda Sagar Kong versus Municipal of Bombay, State of Mysore, etc., this court held that as to whether provision is mandatory or directory would, in the ultimate analysis, depend upon the intent of the lawmaker. That is the most important common to all decisions. That where it cannot be directly concluded whether it is directory or mandatory. Intention of the legislature is to be found out by your lord.
The ultimate.
That's the ultimate. That is the main question, and has to be gathered not only from the phraseology of the provision, but also by considering its nature, its design, the consequence which would follow from construing it in one way or the other. Then, the Saiful Uddin versus Abdul Awul Goni loan, this court held that the difference between mandatory or directory rule is that former requires strict observance, while in the case of later, substantial compliance with the rule may be enough, where the statute provides that the failure to make observance of a particular rule would lead to specific consequence, the provision has to be construed. Here, in this case, no specific consequence has been followed, has been provided in the statute. Substantial compliance, it doesn't arise. Either it is to be complied, there is no question of substantial compliance. Either to comply or we do not comply.
Yes.
Then we are similar way, etc., etc. Then mirror what I have said in that is para. Right. Then mirror para 18 I have played mirror para 18 I have placed separately. But para 18 judgment is referred to mirror that I have played separately. Separately, I have filed, that is the decision of Raja Buland Sagar Kong versus State of Mysore versus Kangan. That I have given your lordship, 76, 75 2.
Yes.
Then mirror, similar view in rubber houses versus extra. This court considered the provisions of Haryana control rent control eviction rule, which provided for mentioning the amount of area.
Paragraph?
Para 21.
21, yes.
This is in respect of rent control legislation. In maximum cases, your lordship has observed that shall may, not mandatory. But a provision directory, though the word shall has been used in statutory provisions for the reason that non-compliance with the rule, that is non-mentioning of the quantum areas of rent, did not involve no invalidating consequence, also did not visit any penalty. Then in BS Khurana versus MCD, this court considered the provisions of Delhi Municipal Corporation 1957, particularly those dealing with the transfer of immovable property owned by municipal corporation. After considering the scheme of the act for the purpose of transferring the property belonging to corporation, the court held that the commissioner could not alienate the property only on obtaining prior sanction of the corporation, and this condition was held to be mandatory for the reason that the effect of non-observance of the statutory prescription would vitiate the transfer, though no specific power has been conferred upon corporation to such property. Number the question, your lordship, but here it's provided for transfer of municipal property, permission is to be obtained. If no obtained, so the vitiate the transfer, it has been mandated. So, my lord, question is this: what your lordship is asking? Non-service would vitiate the proceeding, because it must vitiate the proceeding, because a person cannot be kept in dark regarding his acquisition of his property. Then, in the state of Haryana versus Raghubir Dayal, this court has observed that the use of the word shall is ordinarily mandatory, but is sometimes not so interpreted if the scope of the enactment on consequence to flow from such construction would not so demand. Normally, the word shall prima facie ought to be considered mandatory, but it is the function of the court to ascertain the real intention of the legislature by careful examination of the whole scope of the statute, the purpose it seeks to serve, and the consequence that would flow from the construction to be placed thereon. The word shall therefore ought to be construed not according to the language with which it is clothed, but in the context in which it is used and the purpose it seeks to serve. The meaning of has to be ascribed to the word shall as mandatory, as or as directory accordingly. Equally, it is settled law that when a statute is passed for purpose of enabling the doing something and prescribe the formalities which are to be attended for the purpose, those prescribed formalities which are essential to the validity of such thing would be mandatory. Your lordship kindly note that. To do certain thing in a particular manner, that is mandatory. And your lordship says, King Emperor's case, my lord, that is there always, that is followed. Still, those decisions.
Something is to be done in a
Something
particular
in a
manner.
particular manner.
That
You
has
have
to be
done
done
that
in that.
exactly. You have
Not at
done.
all.
Possibly 37 privy council, possibly like that. So that is to be done. That is mandatory. Then, mirror script 24. Finally, come to the last portion. The law on this issue can be summarized to the effect that in order to declare a provision mandatory, the test to be applied is as to whether non-compliance with the provisions could render the entire proceeding invalid or not. Whether the provisions is mandatory or directory depends upon the intent of the legislature, not upon the language for which the intent is clothed. The issue is to be examined having regard to the context, subject matter, and object of the statutory provision in question. The court may find out as to what would be the consequence which would flow from construing it in one way or the other. This language is several judgments. In other way, as to whether the statute provides for contingency of the non-compliance with the provisions, as to whether non-compliance is visited by small penalty or serious consequence which would flow therefrom, and as to whether a particular interpretation would defeat or frustrate the legislation, and if the provision is mandatory, the act done breach thereof will be invalid. Similarly, if we also test this apply, all these provisions cannot be applied in this case. The court may find out in one way or other whether the statute for a contingency of non-compliance. Here in this, we must admit that there is no contingency is followed. Contingency is to be ascertained from the real intention of the party. So these are the gist of this. So to sum up, another one point, your lordships, I am telling you. Suppose requisition, if the requisition ends with requisition, no problem. Take possession, take back possession. If it is for the requisition, how the order is to be passed? If it remains in the file without survey, then again an order will be passed in the file. It will remain in the file. So far as the requisition, 3 and 6 is concerned. 3 and 6 are the concern. So it is only a paper transaction only, paper orders only. And then the second aspect is, if they want to acquire it, the Act 2 is very much clear. A property which is not the subject matter of requisition
Cannot be acquired under
cannot be
418.
So it presupposes there must be a valid requisition. And valid
For 418 to follow.
for follow up without serving notice under subsection 3(2). Can a notification under section 418 be published? I'm just asking. So the consequence will be that the 418 notices will be bad because non-compliance of 3(1).
That may be in case where they want to proceed for acquisition.
Acquisition. I mean, your lordships can mirror the statute.
Because there are two aspects. They can requisition, they can release from requisition.
Acquisition. That is one aspect.
Requisition, they can follow it up with acquisition.
Then mirror.
So what steps will be taken thereafter?
Yes.
For that, the interpretation will not depend upon the future action which will be taken.
No, some impact is there. What I am saying, no notice is given, although in the file is there on such and such deposit.
If there is no valid, if it is held to be no valid requisition,
I am not
then
saying
it cannot be.
I am telling you about the consequence. Number order remain in the file.
That
no
cannot be
notice
executed.
Yeah?
Cannot be executed.
No, I am not. Submission I am trying to make. That I have explained to your lordship. Order remains in the file. 418 published. Compensation, etc., as mirror declared award under section award declared. Then, without serving notice, what would be the date of taking possession? I am just asking. Can a compensation be passed under section 7(3)? It speaks of the requisition period, not for the acquisition. From the date of possession to the date of notification. A period, long period, it may be for 2 years, 3 years, etc., etc. How to assess the compensation? Government can will say and can say on such deposition will be second, or we will say since it is directory, we have not served, we have published the notification, we are entitled to get compensation under the 418 only or under section 7 on the basis. Can that be done? But this cannot be what I am telling you. This cannot be the intention of the legislature. A compensation which is payable under the law cannot be skipped. That notice has not been served. From all these angles, my understanding, nobody, I am not helping anybody. My understanding, it shall be deemed to be a mandatory.
Anything more?
Nothing more.
Mr. Mehra, can you give a short note on this?
Very. I am. Can we have some time, 7 days or 10 days, because I have suffered double jeopardy. Both of my eyes had to be operated in the last week of December. I have to extract one of my tooth. 10 days time, 10 days time will do.
10 days, all right. Yes, Mr. Talukdar.
Raise.
Complete, otherwise this will. No, you have completed, Mr. Talukdar. Yes.
I, in my own way, I try to assist your lordship.
Yes. Thank you, Mr. Mehra.
No, but as I understand, we are always try to.
So today we are in 14th.
Yes.
So can you do that by 27th?
14th? Yes. 27th at 2 p.m. Or like that. Or
2 p.m. will be convenient.
No, convenient. I always reach code at 9:30.
No, if you say I can keep it at 2 p.m.
No.
For filing of this.
20. Yeah. January. He is asking about 26 January.
No. 29.
Just a minute.
29th. What is it? What about?
27. No, they are asking for 28. No,
28 you do not have any problem. All right. Yes, yes, Mr. Talukdar.
28th or 29th, any day.
28. Kindly keep it on 28.
Only the written notes will be filed, nothing more. Yes. Yes, Mr. Talukdar.
28.
Where to continue?
Yes, continue. Only for filing of the written notes, I will be fixing a date.
Yes. 28, no problem.
3:30 3:30 नहीं Due respect to my learned senior friend, my lord, the purpose and object of the statute is to be same.
Milord, I will file, Milord,
Mr. Mukherjee, don't leave.
Milord, you lords, right?
No, that's good. No.
You have made your submissions.
Yes. And for that, my lord, before that, my lord, may I proceed in that way? It is true, my lord, the true intention of the legislature to be gathered to interpret a particular provision. My lord, just one paragraph of two decision, my lord, may I refer to?
Which you have placed.
No, I have not placed.
New decision.
On interpretation. My lord knows, even then for my satisfaction, my lord.
Have you placed those decisions or you
No,
want
no,
to
no,
place
not
new
yet, not yet. Only one paragraph.
Then Mr. Talukdar, do one thing, please give this reference to Mr. Bera so that he can reply to this in the written notes.
It is commonly used by my
Maybe,
lord
but
knows
maybe
that
have,
even that.
since you are
Yes,
because-
yes, I'll give citation.
Yes.
2014, Volume 1, SCC, page 258.
Yes.
Paragraph 19.
19.
19.
Yes.
My lord, may I read this? We cannot ignore that it is a well-settled canon of interpretation that when it comes to construction of a section, it is to be read in its entirety, and its subsections are to be read in relation to each other and not disjunctively. Besides, the text of a section has to be read in the context of the statute. A few subsection of a section cannot be separated from other subsection and read it to convey something altogether different from the theme underlying the entire section. This is how a section is required to be read purposefully
and meaningfully.
And meaningfully. It should be purposively and meaningfully.
Yes.
So, my lord, to read that, my lord,
the entire act has to be read.
Has to be read.
Mr. Bera has also said that. Entire act.
Entire act.
Yes, yes.
Here, subsection 3 cannot be read in isolation.
No. Entire statute has to be read. There is no dispute with regard to this.
Yes. And another one paragraph in this line, my lord. This is 1976-4 SCC 548.
Yes. Yes.
Paragraph 15.
15, yes.
15. Yes. 15 last 3 lines only will suffice. Not the entire. I'm reading from the
read as a whole to extract the meaning and
yes. So it is a settled position of law how to be read a statute.
Yes.
Okay. Now, if I come to the act.
Yes. Yes.
My lord, what is the object and purpose of this act? It is a temporary statute, Act 2 of 1948 Act. The legislature, knowing fully well the consequence the provisions here, section 3, what my learned senior friend has submitted, that order of requisition it is under subsection 3, it is executable. So unless an order is served,
Yes.
and if it is to be executed, then that will prejudice the person concerned. So it has to be read as mandatory, particularly the subsection 2. In my respectful submission, my lord, this amendment of section 3, as Mr. Bera sought to interpret, my lord, this amendment was brought in 1954, and this act is of 1948. The legislature, knowing fully well, my lord, that provision, that the consequential provision has not been provided there. Even in 1954, the legislature did not felt it necessary
To provide for the consequences.
provide for the consequences. And what my learned senior friend has submitted, that is, it's a cessation of property. My lord, I respectfully submit, it is not a cessation of property. It is cessation will take place when section 4 will be invoked. Here the government, if we read the language, when the government has intended for any public purpose that this land is needed. Here one line, my lord, may I read from section 3, last portion, without reading the section as a whole. In such purpose, may by order in writing, requisition any land, and may make such further order as appear to it to be necessary and expedient. Here two part is there in my respectful submission. In first part, the state government may by order requisition any land which according to the government
is necessary
for public purpose, and may make such further order. So requisition is one part, and may make such further order as may, here also may make, the state government, if feels it necessary, may make such further order as appear to it to be necessary or expedient in connection with the requisition. So if it becomes necessary, the state government may make such further order also. So the order of requisition, then it provides then the subsection 2, an order under subsection 1 shall be served in the prescribed manner. Prescribed manner is prescribed in the rules. There is no dispute. Whether this is to be construed as mandatory or directory, that's the question here. If the legislature, had it been intended by the legislature would have made the provision as has been made in section 7A. If your lordship kindly comes to section 7, section 7 provides for, makes provision for making compensation. No time limit is provided, no consequence is provided. The legislature felt it necessary. That is why the section 7 was amended by section 7A.
Yes.
There,
yes,
a provision for penalty is provided. If it is not made within such and such period, the notification shall lapse. The 4-1 shall go. Whereas section 7, in section 7, the language, from the language of section 7, lordship will not find that within how much time, and what would be the consequence if the collector fails to make an award within such and such time. So it was never the intention of the legislature to make it mandatory. So passing of award, when it was failed by the legislature to make it mandatory by prescribing the time limit, Section 7 capital A was incorporated.
Yes.
So subsection 3 of Section 3, the process of execution which is provided there does not itself it can be construed that the provision of Section 3 should be considered as a mandatory one. Because here after
How an order will be complied if a person does not know?
Here that question, this is akin to 9.3, what has fallen from.
I'm asking you, 9.3 is a different thing. Here is an execution that is not there in 9.3.
9.3.
That was for putting question to Mr. Babera.
Yes.
9.3 is not execution. Here it's execution. Without service, how can we execute? How can a person comply without service?
That
it says compliance. Compliance means, as in contempt, you are coming and saying, it was not served, I was not aware. How can I comply? So if a person is not served, how can we expect compliance from that person? And first is the that person is to be given an opportunity to comply. If not, then execution.
Subsection 3 says.
Subsection 3, first is he is to comply.
Yes.
If he fails, then execution.
Then execution.
So compliance without serving, how can he comply?
Here, if we one judgment, if your lordship considers, perhaps on earlier occasion, my lord, I have placed that 1976, our High Court, sorry, 76 SCC online, Calcutta, page 10.
What is the cost title?
Shaktipada Mandal.
Shaktipada Mandal. Do you have a copy of that?
I have a copy if I have not handed up. Yes. If your lordship kindly considers 1976 SCC online cal, page 10. Few paragraphs.
No, this is on section 3, subsection 3.
On requisition.
Yes.
Just. This is on section 3. 3.1.
Yes, show me that portion.
There was a challenge to requisition.
Yes.
To lordship, for a cursory glance, my lord, paragraph 1, last portion.
Yes.
What is just now fallen from your lordship, if your lordship will find at para 2.
Para 2,
few lines I am just referring to as it.
Yes.
Appearing in support of the rule raised as a threshold before me, in challenging the said order of requisition, he firstly contended that the order suffers from non-application of mine because the authority was not aware for what reason the property was required, and he did not form the requisite opinion.
No, service of notice is not in issue here.
Service of notice is here, not directly.
So we are on the service of notice. This is not an issue. Service of notice is an issue now. This does not deal with that. This
whether the person concerned deserves to be put on notice that,
Yes.
that 8 last portion, if you like.
Paragraph 8.
Paragraph 8 last portion.
Yes.
It is, I am reading from the last 5 line. It is entirely, it is a
the matter entirely
for the government and its officer to ascertain. The courts cannot interfere in such a case and say that a particular object would be achieved.
No, this
by
is
the-
object with regard to the object of requisition.
yes, that is not the.
This was with regard to the object. That's a different thing altogether.
No. Now, Lordship, kindly come. 12, paragraph 12.
Yes.
The last contention of Mr. Bhattacharya was the petitioner were not given a reasonable opportunity of showing cause.
This is a different thing. Nature of hearing is not contemplated.
There has been violation of
No,
the
this is
principles
a
of
different
natural
thing.
justice. He was not.
Here an argument was made that an opportunity of hearing prior to requisition is to be made. Act does not contemplate that.
Act does not count.
So we are not on that. We are on service of the order.
If your Lordship kindly considers paragraph 14 for my satisfaction, Lord. Paragraph
Yes, yes.
The question whether the principle of natural justice applied to the facts and circumstances of a case has been the subject matter of controversy for quite a long time. It is not necessary to refer to any decision earlier than the case of so and so. Rules of natural justice are not embodied rules, nor can they be elevated to the position of fundamental rights. As observed by the court in so and so, the aims of rules of natural justice is to secure justice, or to put it negative.
You can turn over to the next page. Start from the second line of that next page. But if on the other hand,
in that paragraph.
Yes, paragraph 14.
It's true.
Next page. Turn over to the
Yes,
next
yes,
page.
yes.
But if on the other hand,
A statutory provision either specifically or by necessary implication excludes the application of any or all the rules or principles of natural justice, then the court cannot ignore the mandate of the legislature. Or
we are
the
on
statutory
this. Here the statute does not
provide.
So we are not on that. We are not only on the service of the order,
But
whether it's mandatory or directory.
That consequence, when the legislator did not felt it necessary to provide that if it is not served, what would be the consequence? That is nowhere in the act.
Paper order. Cannot execute.
So
you keep it in the file, don't execute. Because question of compliance do not come. So first you have to give an opportunity to comply, then execution.
That is why according to me, subject to correction by your lordship, that what the line I have shown to your lordship, that subsection 1, last 2 lines, that requisition and may make such further order.
That order has been made. First, further order is to take possession. Requisition is, I am requisitioning.
Yes.
Further order is when the possession will be taken, which lands, whatever. So, effect is possession. Compliance is possession. Requisition is not an executable order. Executable order is the further order. Unless there is an order of possession, nothing remains to be executed. What will execute? So, executability is the possession order. So, question of compliance without service does not come. And you have to first give an opportunity to comply, then execute. Anything more, Mr. Talukdar? Other decisions you have relied upon.
If your lordship,
Because according to you, your contention is the consequences have not been
provided,
so it has to be held to be a directory one.
for holding it as a mandatory,
Consequences has to be provided.
consequences
So
has to be
according to you,
provided.
here consequences has not been provided, so it's a directory provision, not a mandatory.
And
This is the sum and substance of your argument.
and also we may take take help of the other provisions which
Yes.
were intended to be made mandatory. Their provision has been
Yes.
specifically made.
Otherwise, it will lapse.
Otherwise, it will lapse. So when the legislature did not felt it necessary to provide such a,
When in this case, when requisition was made,
1976, I think.
1970,
76.
76.
76.
Anything more, Mr. Talukdar?
My lord, just two decision I will be referring to. In Major's case, several judgments were considered.
For
I'm
what
not repeating.
proposition?
I'm not repeating. Only two judgments referred to in Major's case. Two paragraphs, my lord, I will be referring to.
Yes.
That is, one is 1981, volume 1 SCC 403.
Yes. You want to refer from May George itself?
No, no.
Or you want to refer to that decision?
The decision itself.
Yes. Give a copy.
That will be better, my lord.
Writing code.
This is 1980, volume 1 SCC 403, paragraph 9.
80.
Volume 1, 403.
Paragraph 9.
Paragraph 9.
403.
What has fallen from your lordship and what is submitted by Mr. Bera, it is true that there is a provision, my lord, in section subsection 3 towards execution, whether that will itself make the provision mandatory.
Yes.
My lord, may I read this paragraph? The difference between a mandatory rule and a directory rule is that while the former must be strictly observed, and in the case of latter, substantial compliance may be sufficient to achieve the object regarding which the rule is enacted. Certain broad proposition can be deduced from the several decisions of court regarding the rules of construction that should be followed in determining whether a provision of law is directory or mandatory may be summarized thus. The fact that the statute uses the word shall while laying down a duty is not conclusive on the question whether it is mandatory or directory provision. In order to find out the true character of the legislation, the court has to ascertain the object which the provision of law in question has to subserve and its design and the context in which it is enacted. It is the object of a law is to be defeated by non-compliance with it. It has to be regarded as mandatory. But when a provision of law relates to the performance of any public
Yes, I've
duty-
seen that. Paragraph 9.
Yes. The invalidation of any act done in this regard of that provision causes serious prejudice to those for whose benefit it is enacted, and at the same time who have no control over the performance of the duty. Such provision should be treated as a directory one. Then if I skip 3 lines, a procedural rule ordinarily should be construed as mandatory if the defeat in the act done in pursuance of it can be cured by permitting the appropriate rectification to be carried out at a subsequent stage. Unless by according such permission to rectify such error later on, another rule would be contravened. whenever a statute prescribes that a particular act to be done, what is that Mr. Bera also
Yes.
said that. The only one more.
For what proposition? Don't multiply on the same proposition.
This is to some extent different, only one paragraph.
Yes.
All these were considered in Major's case, even then. Paragraph, this is 2003, volume 3, SCC 433.
Yes.
Paragraph 7.
7. Yes.
Yet another aspect of the matter which cannot be lost sight of. It is a well settled principle that if a thing is required to be done by a private person within a specified time, the same would be ordinarily be mandated. But when a public functionary is required to perform a public function within a time frame, the same will be held to be directory, unless consequences therefore are specified. In Sutherland, so-and-so case, so-and-so edition, it is referred to, it is pointed out that a statutory decision to private individual should generally be considered as mandatory, and the rule is just the opposite to that which obtains with the public officers. Then, Millard, the quoted portion, a corollary to the rule, outlined the above. The fact that no consequence of non-compliance are stated in the statute has been considered as a factor tending towards a directory construction. I'm on. But this is only an element to be considered and is by no means compulsory. When the statute does not say
provide for the
consequences, it has to be regarded, Millard, as directed.
Anything more?
And the judgment, Millard, on the last occasion I have cited.
Need not repeat those. You have your sum and substance is that the consequences has not been followed, and you are relying on those line of decisions which says
yes,
unless
my learned friend had relied on Shailendranath this case, where all these were not considered. I had submitted that since, Millard, the law is settled, which was not taken into consideration while passing the judgment, should be treated as per incurium. And on that score, Millard, I have relied on, Millard, 1990 volume 3, I have relied.
Yes,
I'm
Mr.
not
Mukherjee.
replying.
Yes, Mr. Mukherjee.
When kindly see the Act 2 of 1948, two things. Section 3, requisition. Section 4, acquisition. And Section 5, when I kindly see Section 5.
Yes.
Kindly see Section 5. After publication of notice under subsection 1A of Section 4, collector shall call public notice to be given conveyance place or near the land acquired, stating that government has acquired the land and the claims compensation on assessment. State the particulars of the land. But Section 5 has been complied with. Section 4 has been complied with. But if Section 4, he has got a remedy to make an objection. Assuming for a moment that Section 3(1) notice was not served, for a moment, just. But Section 4 notification has been published, Section 5 notification has been published. Has it been affected by right to the property? Because, kindly see, right to property in the land, according to the definition of the Land Reforms Act, there is no concept of owner. Concept is Rayat. State government is the owner of the land under Article 294 of the Constitution of India, when the Constitution came into force. Then Malad, the land was holding, he is a tenant under the state. Then Malad, whatever right, his right to cultivate or what acquire the land. Under Section 2, subsection 10 of the Land Reforms Act, 1955, and Section 2, subsection. Whatever is connected with that is a land. And
where is the necessity, Mr. Mukherjee, to pay compensation?
Malad?
State government is the owner of the land. the person.
Right to occupy.
Where is the scope of paying compensation?
Compensation, right to occupy the land. I am depriving his right to occupy the land, but
So
not
that
owner.
right is being
No,
taken
yes.
away.
No, taken away,
So
but
right in a property is being taken away. For that is compensation.
compensation. Then, but when Section 5 notice is published, Section 4 notification is published, can that acquisition can be invalid?
Mr. Mukherjee, it's now judicially settled that there cannot be an acquisition under 4(1)(a) if there is no valid requisition. So, if the requisition is faulty, everything goes.
But who can complain? Who can complain?
No, that's a different thing altogether. So, everything subsequent is honest in the eye of
But a
law.
public purpose, we are
All
this.
the subsequent stages, if the initiation is bad, all subsequent stages are bad. Without any authority.
Kindly see Section 3, subsection 2, kindly,
Yes.
excuse me. An order made under subsection 4 shall be served in the prescribed manner on the owner of the land where the order relates to the land in occupation or occupier or not being owner of also on such occupier.
Yes.
Mr. Bera has placed the rules.
Yes.
Prescribed manner for the relates to the land. There is no such provision. If this is not done, or this notice is not served, entire thing will go.
So consequences has not been
mentioned.
That's exactly what Mr. Talukdar is
Yes,
saying.
sir.
If the consequences for non-service has not been specifically stated in the statute, then it cannot be a mandatory provision.
No, that's why. That is. In Major's case, last paragraph.
Last paragraph.
Yes. Paragraph 25 and 26.
26 deals with section 9(3).
9(3).
What was the affectation of the right? Yes, I've seen
The
that.
law on this issue can be summarized with declared in order to declare a provision mandatory. The test to be applied as to
Because
whether
right to get compensation, right to challenge that will not be affected. That is why it has been held to be a directory.
directly. But Section 5, well, can you see Section 5?
Here is a
Section 5 notification has been published. Section 4 notification published. He has got a remedy under Section 18 or larger compensation amount. He has not availed, and he was not the owner of the particular point of time. He cannot complain because at that point of time his name was not recorded in the record of rights. He cannot claim that at that point of time he was not served with the notice under Section 3(a)(1). He cannot claim. But in my respect to submission, Section 3 is a directory one and in the public interest. Officer conduct discharging the public duties of for enhancement of road and public service, utility service. And his individual right. Individual right has been, if there is a conflict between the public interest and private interest, public interest will prevail. But if there is, assuming for a moment, there is a lapsus on the part of the government for not serving notice under Section 3(1), the public purpose cannot be defeated. But that's why the language used in the statute, Section 3(1), to be read as a directory. Because Section 4 and 5 has been given his right has been protected. Because he can pay for compensation, pay for a higher rate of compensation, he can apply for a higher rate of compensation before the LA judge. But that Section 9(3), which has been decided in various cases, that has been decided because he could make a reference.
Anything more?
And acquisition took place in 76, 77. And award has been published, deposited.
Yes, file your written notes. No, entirety. Everything, your argument has been concluded.
No. And the maintainability of the depreciation.
Maintainability, everything. You have made your submission. This was one of the arguments for which.
We have not made submission on merit of the case.
Actually, it was.
No. First time this point came up, and yes, first time, not on merit.
Yes,
We have not.
on merits, what do you have to say?
My lord, next question would be coming, my lord, whether he has a right to raise this question. On that, my lord, only one decision I will be relying on that. If your lordship considered that,
yes,
if we consider it that he has a right, that the authority was obliged to serve a notice under section.
whether he was entitled to a notice.
So to whom it is to be served?
Yes.
Section 3.2 says that upon the owner or occupier. So on the date of requisitioning,
if he was not the owner or
he
his
was
name
not
was not
the
recorded.
owner, that should be recorded.
Yes, recorded owner.
Only one decision I will be citing. I thought, my lord, that my lord will be deciding this point first.
His matter, not this point, that point, everything. These matters is going on for, I think, more than 2-3 days. This is not such a matter, it should go on for this.
In
So
the
much.
award sheet, my lord, my predecessor's name is there. But no amount, nothing.
তুমি তো বলেছো
64. তুমি তো শেষ করে দিয়েছো।
আমি শেষ করিনি, আমি তো বলি
What-
that point is a very crucial point.
Yes.
Lordship, kindly consider this. And this is, my lord, 2009 on entitlement of notice. Whether he was entitled to notice.
Yes.
Paragraph 8 to 12.
Paragraph 8 to 12. Yes. Yes.
There is no obligation on the part of the collector to hold an inquiry to find out whether there are any other person interested in the land or whether there are vested remindermen in addition to those whose names are entered as the owner, holder, occupier of the acquired land. Nor does the collector have any obligation to issue notices to persons whose names are not entered in the revenue records. Here, pausing here, moment, it is an admitted fact. The erstwhile owner, he did not recorded his name in the record of rights at the time when the land was acquired.
Yes.
Then, my lord, I was reading, this does not mean that the persons whose names are not entered in the revenue records do not have any right in the acquired land, or that they lose their claim to compensation.
They will be entitled to compensation.
Entitled to compensation, but they are not entitled to challenge the requisition. Their interest and rights in regard to the compensation are protected by the provision relating to the apportionment of compensation and provision for referring the dispute to a civil court for apportionment. The person believed that is explained in paragraph 9.
Who is the person interested?
Yes. 10. The collector is not expected to hold many inquiries to find out whether the persons whose names are disclosed, the names are entered in the revenue records, are persons interested in the acquired land or not. Therefore, no person has any right to assert that the collector should recognize him to be a person interested in the acquired land and issue notice to him merely because someone informs the collector that such person is also having an interest if his name is not entered in the revenue records. Of course, if the collector is prima facie satisfied from his records that someone other than those names are entered.
Paragraph 12 is the answer. Paragraph 12.
12 is the answer.
Yes.
Here also my learned friend will be showing in the award sheet, his predecessor's name was there. It is the collector can do it because their right to get compensation is protected.
Yes.
But it is an admitted they mutated their names with the KMC, but not with the revenue authorities. The ROR could not be placed in the writ petition that their names were recorded even then they were not served. Had it been so, then question would have come, my lord, to decide that their rights have been prejudiced. So as far as this case, my lord, according to this, my lord, this petitioner have no right to question that, even if they cannot claim notice. They cannot claim to be served with the notice of requisition, because admittedly their names were not recorded. It is in the process of acquisition, assessing the compensation, the collector came to know that some other persons are interested.
Award has been declared in there.
Award has been declared. So by Milord showing that name, the petitioner cannot establish that their names were ever recorded. Let them show the ROR of that period. They cannot show. And another argument they have made, showing several documents that they were residing there, whether by remaining in possession of acquired land will Milord after vesting, whether that Sadhuram's case, my lord knows, kindly take it in record, my lord. I will be relying on this. Remaining in possession.
Unauthorized occupant, trespasser.
Sadhuram is the law settled here, and that has not been upset by any subsequent judgment. That is 1997, volume 9 SCC, page 544, paragraph 3 and 4. That will not help the petitioner in any manner. When that moot question came, my lord, we thought Lordship will be deciding that question first. That is why, my lord, I have not asked on that. So these two points, they are to face. They are to show that they were the recorded owners at the relevant point of requisitioning. That in spite of deserving notice, they were not served. Even if I accept that it is mandatory, and collector was obliged to serve notice. To whom? He was neither owner nor occupier. 3 and 4, these two paragraphs. Shailendranath Pal's case cannot be the authority, because all these were not taken into consideration. Even the Shaktipado's case was not taken into consideration.
Yes.
And that apart, there has been a delay. There has been a delay, my lord. My lord knows. Though I have brought all these judgments, my lord knows that is to be considered also. So these are the two main parts.
That he is laughing.
He is laughing. I am not also any of the judgments, but these points we cannot ignore. That cannot be ignored also.
No. All right. Ashun.
2010 4 SAG, page 532, paragraph 11.
What? Delay?
A delay.
Swarnalata?
There are
Swarnalata.
subsequent decisions, Mr. Mukherjee, subsequent decisions. Which distinguishes
No, but constitution judgment
and land acquisition.
It's
the challenge of the award.
No, Swarnalata.
This is challenge of the award.
Swarnalata is the decision. And thereafter
and
also let it
64th Supreme Court, constitution judgment, 3 years maximum limitation. 64th Supreme Court, page 1006.
Land acquisition.
No,
Mr.
read petitions.
Mr. Mukherjee, 2022-2023, the Honorable Supreme Court has laid down the law, distinguished between service jurisprudence and this land acquisition matters. Where it has been said, yes, those period of limitation will apply in service jurisprudence where third-party rights are accrued. Here, third-party rights.
No,
this Swarnalata is on acquisition.
Land acquisition.
Consider subsequent decision says no.
No,
It has not been overruled till now. It has not been overruled till now.
After
It has not been overruled by.
All right, I will consider.
In 2012, Lilavanti is also there.
I will consider this.
Malud will consider that on that point. The little
On that point, Mr. Talukdar knows he is not pressing very hard. On delay, he is not pressing very hard.
I leave it to this. But these 2 points, my lord will consider.
Yes. These two
S.
are
Palani and S. Sadhuram. This fits in this case. Apart from the construction.
Heard the matter is going on for long. Last hearing was, I think, in December 2025.
Before Christmas.
2-3 hearing in this type of matters, more than 2-3 hearings.
No, I thought Lordship will be considering that point first.
No. What that? He argued extensively.
He has argued. I have not answered.
Now you have answered. Heading.
আজকে 3:30 আমরা